keeps me from my winter hell. I've got candles and candy, I can be your daddy if you only let me creep into your prison cell. Hey baby, can you tell I'm not a criminal? Your choice is seminal. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. Just speak low, stand in your row, try not to show this life's a show. Try not to glow way down below. Oh, it's a lot of woe, and that's not a place where you would like to go. I've got cigarettes and brandy, which could come in handy if you just help me loosen up my hand grenades fuse. Baby, don't refuse my truth, but it's up to you not to choose. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true, 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 true.
Good morning, everyone. How are you? It's good to see you. Let me say hi to you guys. Good morning, Mrs. Troy. Good morning, Sissy's mom, Gretchen, preschool granny. Becky P. Good morning. Sarah Bellum. Good morning, you guys. How are you? I hope everybody's good. Good morning, Sprinkled Donut. All right. So, yes, the jury is going to be going on a field trip, but so are we, because the day won't be over for us over here at the ward. No. We have places to go and things to see, because guess who also has a hearing this morning? Billy Wagner. So if you didn't get enough rage at whatever the heck Judge Bev is going to pull today, all right, we're going to have more rage to come from the judge in Ohio with Billy Wagner. I'm guessing that what's gone on is okay, so the judge made a ruling, and now I don't even remember what it was that the state appealed on. I think it was taking the death penalty off the table, if I remember correctly. He's already sentenced Angela and Jake, which that was an absolute dumpster fire and just not justice at all, particularly his little speech. Ugh. Anywho, that's where we'll be going after we when the jury in the Karen Reed trial goes on their field trip. That's where we'll be going now. There's a little scheduling conflict because the Billy Wagner hearing doesn't start well, it starts at 9:00 my time, so 10:00 Eastern, but I'm not going to switch over to that until the court is done with this, over here at Karen Reed. I don't even know why I'm trying to talk this morning. I've got no business trying to be running around and telling and describing what we're going to do today, because I can't even get it straight in my own dadgum head. But anyway, that's what we're going to do. Good morning, Tosh. Good morning, MK Lean. Hey, MK, how'd your yard work go the other day? You still got enough dandelions in your yard for profit? Good morning. It's good to see you. So yeah, let me show you what's going on in the courtroom currently. We have a lovely view of the fan. Our only fan friend is back. So that's happening, yes. Also, okay. So there's been some stuff I see in the side chat. Sissy's mom is talking about it. Lori Vallo's reaction. Okay, here's the deal. All right. So this weekend, because my husband's not on call, we're going to go get the moving truck, and get the stuff out of the storage. So that's probably Saturday.
And will be muted throughout the meeting.
Okay. Thanks, Judge.
The host would like you to.
Thank you, Judge Bev. Anywho, what I plan to do is a Sunday live, and we're going to catch up with Vallo, because we watched that trial as a family. We're going to see the verdict as a family. We're going to get all the reactions as a family. It's going to be one big, giant recap. So we can all be angry, glad, all at the same time, in the same place, all together, the way a family should. All right, here we go. Oh, we're already at it. We're two seconds in. My goodness. And we're already at a sidebar. Lord. Oh, dear. Oh, dear. MK says, Jenlu, they are slowly wilting, but we'll probably be back in a week with a vengeance. And you will know my name is Dandelion. When I lay my vengeance upon thee. It's such a good movie. Anyway, so that's what we're going to do today, because I need to look, Billy Wagner. This is why I'm concerned about what's going on over there in Ohio. Okay. The case against Billy is not as strong as the case against George and Jake. Even if Jake had not testified, okay, and not turned state's evidence, the case against those two was stronger, okay, because there was, they have like the wiretaps or whatever. Hold on a second. Oh, okay. This isn't for my part of the, anyway. So the case against Billy Wagner is weaker than it is against George and Billy, or George and Jake, excuse me. And so I have great concern, especially since Jake and Angela have now been sentenced. And I think they're still arguing like change of venue and some other things. And hey, Carol, good to see you. So yeah, I need to get over there and see. And I'm just so annoyed with this judge. Like I can't even talk correctly.
All right.
Because I'm so annoyed with this judge. I'll have to look when they swing back around, Gretchen. I think that she is likely a paralegal, and she is in charge of, like, when they want an exhibit displayed or they want a clip played. I think she's doing that, which, now that I think of it, that would be a fantastic job for me. I'm very good at sharing a screen, showing a clip, toggling between multiple screens. That would be a fantastic job for your girl. But but then I couldn't say what I wanted to say. See, this is where being professional in a professional setting, i.e., courtroom, this is where I I don't know if I could shine there, because yes, I could do all the things respective to, showing. I could put together the presentation. If I put together Karen Reed's presentation of evidence, can you imagine a soundtrack, all the things, little memes in there, little gifs in there. But I wouldn't be allowed to comment, and that's the problem. That's why I like it over here on YouTube, because I can. I need to be able to express my outrage and my irritation. And sometimes when things are funny, and especially when they're ridiculously funny, I have to be able to speak on it. So, oh, I forgot that I need to get the damn clip. And I was thinking yesterday when I was watching some things that we need the oh gosh, Mommy Dearest gif. This whole place is a mess. We need that, because I get frustrated. Like, there's been some things that have happened, some rulings with Judge Bev that Judge Bev has made, the Freudian slip by the prosecutor when he said influence interviewed. Yeah, I can't do it. Snark and what is it? I have to look at this. That's one thing I wish, like, Streamlabs and even StreamYard, which I don't use StreamYard anymore, but because I feel like they're too expensive and they don't offer you. I don't. There's no reason that. Yes, spice and snark. Thank you, Sarah Bellum. They don't offer anything that to me is worth $45 a month. I don't pay $45 a month for Streamlabs. And even if I switched, and because this is the Talk Studio from Streamlabs, okay? But even if I went full Streamlabs, no Talk Studio, it still isn't $40 a month. It's not even, I think it's like 20. It's like 19 and some change. It's still half the price of StreamYard, StreamYard. And on top of that, you can do so much more if I were to get the full version of Takeouts, the Talk Studio, which is similar to Streamlab, but, like, I could do so much more. I could have multiple screens on at the same time. I could change the layout to be really cool, all of the things. So, it is what it is. Oh yeah, Gretchen S. This whole trial is a mess, and I think there will be appellate issues. I agree. Here's the thing with me. Okay, so OBS, even Streamlabs has a free version, okay, which is similar to OBS. And you can do a ton with that. The thing about the thing about getting free versions of things is that the free version has their, like, logo and stuff like that. So for me, it's kind of, I like to use my own stuff. And but for now, um, I'm gonna use the Talk Studio because I like it's so similar to StreamYard in the way that you can have a guest on a panel and it's easier for the panel guests to use. And I would have to keep Talk Studio anyway if I wanted to have guests up. So, I don't know. I'm thinking about it, but I got a lot on my plate right now, and learning the Stream Labs way of streaming is there's a learning curve to it. It's not like I got a lot of it down, but not all of it. And I just don't really have the time right now to like do all the, do the learning that I need to do. Hey, Tess, good to see you, babe. Morning, Neat Noodle. Good to see you. I don't know what we're doing. I don't know why I don't know what's happening. Is the jury late? I don't know. I don't know what's going on. But anywho, for anybody that's just joining us, when the jury goes on their field trip, which I heard somewhere that it's going to be at 11:45 Eastern time, so that's 10:45 our time. What we'll do then is switch over to Billy Wagner in Pike County. He has a hearing this morning at 9 a.m. Central, 10 Eastern. So when the jury goes on their field trip, we'll be going on a little field trip of our own. We'll be going over to Ohio, seeing what's going on. So, yeah. Then I heard there was another hot mic moment, and I'm trying to find it. This time it was from the prosecutor. And it was when Carrie Roberts was testifying, and she was on cross. And allegedly, there's a hot mic moment with the prosecutor who says, "You can answer that." I need to find that clip. If anybody knows where to find that clip, please. Let's see. Here's my email. Please send it to me. Yes, MK. We're going to come to Ohio to see MK and the world famous dandelions. the dandelions for profit. That's where we're. I know, Gretchen. I didn't hear it either. And if push comes to shove, and I can't find that clip, and nobody knows where it is, what I will do is I will go back through the testimony of Carrie Roberts, and I will find it, and I will clip it, because that's huge. What is going on? And come on now, look, I'm tired of looking at the fan. Let's get this show on the road. Let's go, Judge Bev. Oh, Tess, thank you so much. Tess, TikTok has a function where you can search your history. Just as handy as Control F. Just saying. Also, while we wait, we haven't seen our good friend Reebok in a while. Let's watch this. Let's watch Reebok, and you guys run on over to the like button and give your girl a thumbs up. Here we go. I need to fix that. I'll do it. All right, so they're not going to start until 10 o'clock. What? Hold on a minute. Let me see. Let's go back a little bit. Let's see what's happening here.
About something?
Yes, please.
All right. Why don't you come on over to side dog?
Come over to side dog. Even the captions are done with you, Judge Bev. So what? We got to sit here for an hour, Tess? Hold on. Let me see what's going on over here. Hold on. Because usually there's a pinned thing. Let's see. We'll see. Anyway, you know what I'm curious about? Do you guys think that, hold on, ouch. Okay, Tess. All right. I know that they were going to take the jury on the bus and it was a half day, but I'm curious if this is all that they're doing today. Like, is there going to be any testimony today? And then they go on the field trip, or because that's happened before too. But I just wanted to be sure. And look, if that's all they're going to do today until I find out for sure, obviously, right? Did I put it back live? No. Let me make sure. Let me put it live. There we go. Because if that's all they're going to do today, then we'll just, chit chat, and then I'll switch over to Billy Wagner's hearing, and I'll just change the thumbnail and everything like that. So the person who didn't come yesterday. Okay. See, that's what I wanted to talk to you guys about. All right. So yesterday, the whole reason we had a half day is because the state said that there had been a mix-up in scheduling, and that they thought there was a witness that they were going to call that then wasn't there. Okay. I have to say this because if I didn't say it, it would bother me. I find that suspect. Okay? Because think about what we ended with yesterday. We ended with those text messages. And to me, those text messages were no big deal. I thought that they showed a couple who probably doesn't communicate the best. Do I think that John and Karen were endgame? No, I don't. But it's clear to me, the only thing those texts really show to me is that they they played games with each other. They poked each other, really. But I do think that the true status of their relationship, in my opinion anyway, was revealed in the text where John tells her, just tell him not to do anything. I'll fix it on Monday. He didn't want her driving around all over Hell's Half Acre, back and forth between Canton and her home over the weekend because of the blizzard conditions. And, if you don't care about somebody, if you don't, have love for somebody, you don't offer them that. And also sounded is not the right word. When she was talking about going back to her house over the weekend and not staying with him, he was like, wait, I thought you were going to stay with me. So I felt like those messages didn't really show anything at the end of the day. I mean, they don't prove one way or another what we're actually here what the jury's actually tasked with determining. I don't think they showed that. I don't think they showed anger by either party. I don't think they showed anything really relative to what we're here to figure out what happened, right? Just was a big, huge nothing burger to me anyway. So, yeah, that's how I felt, Gretchen. They just sounded like an exhausting relationship. And, Tess says, I think the text made John not look the greatest. It was not super detrimental. See, that's me. Like, no person is perfect, obviously, and everybody is human. And I think that there were times when they got frustrated with each other, and that means absolutely nothing to me anyway, as far as this goes. These were not. Hold on a minute.
Yes, please.
See what's going on here.
Should be 1 minute.
Okay, thank you.
And then I got something to tell you guys yesterday, too. That has absolutely nothing to do with this.
What? You absolutely did not. Come on.
I think what we had in the relationship between Karen and John was a very unique set of circumstances, okay? John went from being an uncle to being a father, okay, to having the role of the father. I know from experience I've never been an uncle, but I am an aunt, and I know from that experience. And then at one point, when my sister was in school, I had my youngest nephew for like a month, full time. And it's different having them full time versus just being the fun aunt, right? The fun uncle. And even then for me, the circumstances were a little bit different because I was already a mom. So now we have John who was living, the single life, footloose, fancy free. He's all of a sudden become, taken on the role of father, full-time, raising 2 children. And then, so when he and Karen got together, that had already happened. So, Karen was well aware of John and the children being a package deal. But John, I think, was still struggling. It's not easy going from footloose and fancy free to being a parent. At any point, whether it's from newborn on or, under these circumstances.
Holding in Dedham within and for the county of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
And this.
For the record before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. Our 18 jurors are present. The matter is on for trial.
Thank you very much, Madam Clerk. Good morning again, counsel. Good morning again, Ms. Reed. Good morning, jurors. Good morning. When we leave you out there, we're very much aware that we're leaving you in another room waiting, but we were working this morning to help streamline things, and we were successful, so we do appreciate your patience. I do have to ask you those questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone nodded affirmatively or said yes. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did any of you happen to see, hear, or read anything about this case since we left yesterday? No. Thank you. Everyone said no. All right, folks, as you know, this morning we are going on a view. And a view is simply, we're going to a place that you've heard about and that you will continue to hear about during the course of the trial. The purpose of the view is to help you better understand the evidence, which you'll hear during the course of the trial, and to help you appreciate the location and its surroundings. So the view that we're going on is part of the case, and it means that the observations that you make there can be used and considered by you in your deliberations on this case in reaching a verdict. So we're going to, you've heard, 34 Fairfield Road in Canton. The lawyers and I will accompany you. For the Commonwealth, we'll be accompanied by Attorney Brennan, and ADA Lally, ADA Schillinger, and for the defense, Attorney Yannetti and Attorney Little. The lawyers will have the opportunity, Mr. Yannetti and Mr. Brennan, have the opportunity to point out various things that they may want you to direct your attention to. Otherwise, there's no conversation between the lawyers and the jurors. So it's simply, in a few minutes, you'll hear a little bit from each Mr. Brennan and Mr. Yannetti about what they want you to look at. And then when we get there, they'll direct you, look in this direction. They won't be able to testify to you, but they'll direct you on what they want you to look at. While you're in the view, you're not to take any notes, you're not to take any pictures, you're not to conduct any independent investigation at all during the view or any time during the trial. You're not to return to this scene or ask anybody to go back there for you. Today's your chance. You'll see photographs during the course of the trial, I bet, but today's your chance to really look at everything. So the best way to summarize a view is that your job is to simply stop and look. It's really no more complicated than that. So your responsibility is to see the place, observe it carefully, and to remember what you see. Now, during the trip to and from the view, and while at the view, you're not to discuss this case or anything about it with other jurors. Will be accompanied by court officers who will direct you, and the court officers are there for all of us. So you'll be under their supervision until you're returned back here. So that's basically it. We'll be leaving in a few minutes, but first, before Madam Clerk swears the court officers in, Mr. Brennan, do you want to make a view opening?
May I?
Please.
Thank you, Your Honor. Good morning, ladies and gentlemen. As Her Honor explained to you, we're going to go to 34 Fairview Road. You have some exhibits that are already in evidence. You haven't had a long time to look at them and study them. But essentially, we're going to go to 34 Fairview Road. I ask you just to pay attention to the street, the front yard of the home. And you'll see to the left side of the front yard in the corner, there'll be a car. It's the Lexus that we've spoken about, the defendant's Lexus. And you'll also see a flagpole and a fire hydrant. And so I'd ask you to take a look from different vantage points. Take a look from that area where the flagpole is, from where the fire hydrant is. And you'll see on the street before the grass is a little berm, concrete that comes up a little bit. I'd ask you just to note that when you go there. One thing I'd suggest is April 25th, 2025, not January 22nd, 2022. So the weather will be very different. The temperature will be different. The conditions will be different. We're going to go there probably at 10 o'clock. It won't be the same visibility. It won't be the same elements and the same weather. So keep that in mind when you're looking around. When you look at the Lexus, there's a couple of things I'd ask you to look at. There is some evidence already of photographs of the right rear tail light. When you look at that tail light, it will be different than the photograph that is in evidence. It has been removed, so it will appear differently, and you'll later hear testimony explaining that process. Also, I'd ask you to make a note on the Lexus about the height of the bumper. I'd ask you to make note of the height of the right rear tail light. And I'd also ask you to take note of, on the top of the hatchback, there is a part that protrudes. I'd ask you to take a look at that as well. Thank you very much.
All right. Thank you, Mr. Brennan. Ms. Tianetti?
Thank you, Your Honor. Good morning. As I told you at the start of the trial, my name is David Dinetti. I have an office in Boston and in Dedham. And on behalf of my co-counsel, we will be accompanying you on the view that you will take today. Although the view is not evidence, I suggest to you that you will find it to be helpful, important, even necessary as you later do your investigation of this case within the four walls of this courtroom. You've already received into evidence, some photos and videos, but there is no substitute for your own two eyes. As we all know, photos and videos sometimes can be misleading in terms of relative distances, depending upon the perspective from which the photo is taken. But your eyes are the best computer that you could bring to the view. When we get to 34 Fairview, we will be pointing out certain things that we'd like you to observe. The house, the second floor window to that house, the three front doors in the front of the house, the driveway, the street, the front lawn, and the flagpole. And we'll be asking you specifically to consider the distance between that second floor front window and the front lawn. the distance between the front doors to the house and that front lawn, the distance between the driveway to the front lawn. And we'll be asking you to take a good look at that Lexus, to stand next to it, to size it up, to take it in. You were all selected as jurors because the parties entrusted that you would do a proper investigation of this case within this courtroom. On behalf of Ms. Reed, we have every confidence that you will do a proper investigation. Thank you.
All right, jurors, I have to make something very clear. So the purpose of this view is to help you better to understand the evidence that you'll hear during the trial and to help you appreciate the location and its surroundings. The view you'll take is part of this case. The observations that you make while on the view may be used and considered by you in your deliberations in reaching a verdict. So at the end of the trial, when I explain to you what is evidence and what is not, I'll remind you that your observations on this view can be used by you in your deliberations. Also, while you're in the view, the same way you're not to take any notes or photographs, you're not to conduct any investigation on this case. You really are simply to stop and look, okay? Those are the instructions. We will see you in a few minutes. All right, thank you. Oh, sorry, Madam Clerk has to swear in the court officers.
You could all raise your right hand, please. Do each of you solemnly swear that you will take the jury upon the premises in question and there suffer them to view the same or any property, place, or thing bearing upon the issue in the trial as the parties may think necessary, that you will not permit the parties to enter into a debate in the hearing of the jury, nor any person to speak to them unless it be the attorneys of record, then only to point out such places or things as they may deem expedient for the determination of the issues, that you will keep the jury together until they shall return to court, unless the court shall otherwise order, so help you God. Thank you.
All right, thank you.
All rise, please. Jurors, follow me.
All right, so they are going to go on their field trip. We're going to go on a field trip too. We're going over here. Hold on a second. What am I doing? Hold on. Give me a second. I need to do it a little differently. How can I? All right, we're going to go to visit Pike County in about 25 minutes because Billy Wagner has a hearing this morning, and I'm quite curious about how that is going to go. I'm over here. Let's see. I'll put this on the screen because I want you guys to see this really quick. And I can't change the view because they're not live yet, but I never noticed these tattoos before on Billy. I don't know how I missed it. I don't know why I missed it, but I did. Clearly. So, this is what we're going to be looking at, or this is where we're going to be going while the jury is on their field trip. And I'm thinking that if it's a half day today, how long do they expect to be on this field trip? But I will check back. So this is going to be a mix of Billy Wagner's hearing, then whatever, when they get back from the field trip, we're gonna we'll listen to Billy Wagner's trial. When they're back from their field trip, we'll go back to Massachusetts, then they'll break for the day and whatnot. Sarah, I don't think that they're new. They don't look new in this picture. This picture that that they have used in their thumbnail is from trying to remember when this was, because I do know, just trying to remember. I feel like it's from when he started when his pretrial hearings started. I don't think it's from his first appearance. I think that photograph is from the beginning of when, oh, okay. Thank you, Tess. So that's what we'll do. I have the trial, window pulled up. And so I can, hold on, let me see this. I have it like on my other screen and it's in the queue so I can see it. So when they come back, we'll just go back there. So this will be a little bit of a mix. That's what we're going to do. I'm curious as to what I need to change. I do need to change the description though. Let me open up a 15th window and go over here and change this because I do want to I do want people to come if they want to hear also, because I know there's a lot of people that are invested in the Billy Wagner trial and what's going on with that and when are we going to finally get to trial and all of those things. So let me edit this description really quick. All right, let me do something right here. Oh my stars, hold on. Oh my stars, I still did it wrong. All right. There we go. All right, so that's what we'll be doing today. What else? Oh, okay. So let me tell you guys, just while we're waiting for all the things to start, what had happened to me yesterday. Good morning, Music City Mom. Good to see you. It's been a minute. I don't know if I said good morning to Neat Noodle. Good morning, Neat Noodle. Good morning, Sarah. Good morning, Tess. Good morning, Rachel. And good morning, Seven Lilies. I think I got everybody. Yes, I think so. Good morning, Michelle. All right. So, as you know, yesterday we had half day with the jury, okay? Because accidentally on purpose, a witness didn't show up for the state. So then that meant they had no witnesses for that day. Now, I want to get back to what I was saying about that because they left the jury sitting with those texts, I think, on purpose, even though they don't prove anything. But I think that's what they did because at the beginning of the day yesterday, Judge Bev asked if there were going to be any expert witness testimony, if there was to be any expert witness testimony yesterday. And what did the prosecutor say? No, Yana. Okay. Usually, scheduling conflicts arise with expert witness testimony. Something comes up, travel plans, like, a plane getting delayed, those kinds of things. Okay. Not typically with lay people. Can it happen? Sure. But I just feel like, I don't know, it's a little too close. It just feels a little not right to me. Okay. That's it. That's all. And I think it's interesting because in the first trial with Karen, I knew the basics of the case. I did not know all of the details and how everybody fit together and all of that, but I learned very quickly. And in the first trial, I really tried to be I'm very cautious when it comes to criminal cases and there being like a conspiracy or shadiness in the department, corruption on the part of law enforcement, because the amount of people that would have to work together just to target one person, that's a lot, right? But in this case, and I was really, really hesitant to say during the first trial, oh my gosh. But I'm past that point now. Now it's looking improper. Now it's looking conspiratorial. Now it's looking like a frame up. And usually I'm the last person that will say that, but it is starting to appear that way. And yes, Tess, the clips, those clips. Now, what I noticed about those clips is that some of those clips were from what we would have seen on the various news shows like 2020, Dateline, okay? But some of those clips appeared anyway to be B-roll footage, okay? Now, I feel like Karen has got a great team of attorneys around her. I think that not only are they incredibly competent, but I also feel like they actually care about their client and do truly believe in her innocence. And so for them to give her permission, which she doesn't need, she can go against her attorney's advice, but why would she? So I think that the fact that she did those interviews, I think she did those interviews and I think her attorneys were present. And there's a reason they granted and gave their the go ahead to Karen to do those interviews. I suspect that what they're going to do, if anything with that, is after the state has rested their case in chief, I would imagine that what they intend to do is play the B-roll footage to show those clips in their entirety and in context, okay? Because that's why I'm very hesitant when it comes to criminal cases. Will I watch Dateline 2020 if they do 48 hours, if they do a special on it? Sure. But I remember way back, I don't know, probably, I think 2020, maybe, no, it was before that. No, it had to be. It's like 2019, 2020, somewhere where in that vicinity. Was it, I think it was ID Investigates, did a story on the West Memphis 3, the update, okay? The amount of basic facts that they got wrong in the opening where they give the backstory blew my mind. Like they got names wrong. And I'm not talking about names of like side parties. I'm talking about names of the victims. They got two boys mixed up, which it's not really irony. Interestingly, the two boys that they got mixed up, their names were the same two boys that were mixed up in the original investigation. They were misidentified. And they thought that instead of Christopher Byers having the injuries that he had, was it Michael Moore? I'll have to think back on that one. It's been a minute, but they mixed the same two boys up. That I remember. And just so I'm very hesitant to watch things like that and take anything like super important from it or use something like that that's highly, highly, highly edited to, as my foundation for what I believe going into going into a case and trying to figure out what happened, because it is highly edited. And I have to be like, I like with the West Memphis 3 case. Yes, the initial documentary, the childhood murders at Robin Hood Hills, that documentary got me interested. It didn't make sense to me, but it wasn't. I watched that and then I didn't even look into that case until years later on a total fluke. I was looking for something else and stumbled across the West Memphis 3 case again. Anyway, but even that's highly edited. And what's a bummer about all of it, as far as the documentaries go, is that Joe Berlinger and Bruce Sinofsky are the ones who worked on that documentary, on those 3 documentaries, okay? They are the only people in possession of the raw footage of both trials in their entirety. And there is so much good information in those trials that I wish that they would put those out. I wish they'd be put out. They should be put out. Because you can't really appreciate from those 3 documentaries what happened originally in that trial. The rulings that occurred, the fact that in Jason and Damien's trial that Brian Ridge mentioned Jesse's confession, even though Jesse was not a witness. So it should have been a mistrial right then. I mean, there was just all kinds of things. And so I wish that footage would be released. I really do. I would love to see the trial in its entirety. Hold on, I'm going to turn this down just a little bit because it's like in my ear and it's kind of distracting. So anyway, there are times when Judge Bev makes a ruling that it does remind me of Judge Burnett. It really does. And I don't say those things lightly. I know what that means when I'm saying that. So anyway, let me tell you about a little bit of, let's just completely switch gears because in about 9 minutes, they're going to start over there in Pike County. So I want to tell you what happened yesterday. So after we left yesterday, okay, I said to myself, oh my gosh, it's it's April 24th. The final season of You premieres today. And I always do this. It doesn't really matter how many times I've seen it. Whatever. If there's going to be a final season coming out, I will rewatch all the seasons before that because I like to really draw it out. Okay. So I was like, I know what I'll do. I'll go and watch the rest of, I'll keep catching up on you and rewatching it and whatnot, Okay. Okay. Yes, I can. Harley, give me just a second. Good to see you, by the way. All right. So I go to Netflix and I kept getting this error. And it was saying, "Hey, B. Frank, good to see you." And it kept saying, basically, your internet is not working, which I knew my internet was working. Okay. Let me just put a pin in that. All right. So, Harley, what you're going to want to do is you're going to need to go to your Google account. Okay. Like where you check your email. All right. So go over there, go to your Google account, go to personalization, and go to blocked users. And there should be a list, and you'll click on the person that you wish to unblock. That's how you do it. Don't worry if it's okay, babe. Accident, not accident, whatevs. Just that's how you do it. Okay, so I went to go watch it and I kept getting this error. So then I was like, what the actual F? There's nothing wrong with my internet. So then I go to the Googles because I didn't actually know what that error code was. I Googled it. So I did all of the things. All right. I reset my modem. I reset my router. I reset the Fire Stick. All those things didn't even work. Okay. Let me tell you guys what I had to do. There was a big outage yesterday in Netflix. Tons of people in multiple countries were getting that code. And people were mad, mad, mad. It was like how mad people were when the Mike Tyson Jake Paul fight happened. Yeah, that I was one of those people because I watched that. Anyway, so you know what I had to do? I had to first of all, I had to completely reset Netflix, log out, log back in, and all of the things just to watch you. And even still now, I can't even switch. See, my husband and I both, we have one Netflix account, but we have different profiles because he watches different things than I do. And quite frankly, for both of us, hold on a minute. All right, quite frankly, for both of us, if we shared an account like that, it messes up our suggestions because we watch very different things. And I could not even, I couldn't even log into my account. Like I couldn't switch. It was so annoying. I was so mad. I was like, all I wanted to do was watch Netflix. It was just annoying as hell. Which I know was petty, but whatever, I'm petty. This worked out really, really well. Because I think this hearing might be probably just about as long as their field trip, maybe a little longer. So there we go. Okay, let me see. I'm going to read this. You're probably not even listening in here anymore because you're probably doing what you're probably unblocking. But Harley, if you still are listening, MK says, Harley, you have to go to Google account, then look for the people tab, then blocked list, then find who you want to unblock. Yes, Tess. Tons of people were, I'm guessing what broke the Netflix yesterday is the final season of You. So many people wanted to watch it, and they went to go stream it, and Netflix was like, bruh, we weren't prepared. I guess. I don't know. I'm curious if the members of the Roden family will be present today. They have been present for every hearing. All right, I think that back chatter that we're hearing is the camera operator people. Hey, Teacup Kraken. J. Rose. Netflix charges way too much to have issues like that frequently. You ain't never lied. I was so upset yesterday. When I go out, I'm gonna be the man who goes out next to you. Hey, Sissy's mom says they have the radio. They have the radio on, and I'm gonna be 500 miles. The Proclaimers came on. Very hard not to dance and look like an idiot. I doubt you look like an idiot. Did I say good morning, Teacup Kraken? I hope I did. But if I didn't, good morning, babe. Good to see you. Oh. At least they have comfortable chairs in the audience in this courtroom. I just do not like this judge. Ugh. I cannot. I'm like anticipating ridiculousness. And it's already got me feeling some sort of way. You know what? Tess, that's an issue. Netflix has really decided, hey, we're not gonna. It's not good for our business for 4 people in the world to actually be paying for the Netflix account and 70 billion people in the world sharing those 4 people's accounts. So we finna crack down. Yeah, and that's what they're doing. Hey, Petunia, good morning. Good to see you. It's good to see you. See, this is, okay, so my oldest son, his standing Mother's Day gift to me since like 2015 has been Netflix and Hulu, okay? And when Netflix changed their policy, I was like, well, guess I'm going to start getting Mother's Day gifts from now on. Just teasing. But yeah, that was his standing Mother's Day gift to me for all of those years. And he was so proud of himself. So, you know, it was kind of a bummer when it happened, but it impacts him too at his house because it's just Netflix is doing too damn much. MK, how are you going to be a streaming service and not be able to stream live? Come on now. I'm not even I'm just doing this live streaming out of the office in my house, in my apartment. All right. Which I got to tell you guys, you know, you want to hear something a little interesting just while we wait. We've come full circle, my husband and I. Okay. Because our first place was an apartment and now we're back in an apartment. But this apartment that we're living in will be the first place that we have lived as empty nesters that our children haven't lived in. Like, this is the first place that we've had just me and my husband since our kids have grown up. And I thought that I wouldn't really like being in an apartment, that I would miss having a front yard and a backyard and all of that. But I got to tell you guys, low key, I don't miss it. I don't know that I want to go back to that much space, honestly, and that much responsibility for that space. I just don't think I do. And also, I feel like if I got a home, that because I have space, that I would want to get a dog, even though I know I just can't take that heartbreak. I've had to bury 2 dogs. You know, I buried my black lab Baxter, and I just recently, last year, I lost Nestor, and both of those dogs raised the kiddos. You know what I mean? So I just I can't go through that heartache again. I can't. I miss Nestor every day. Every single like I'm a big salad eater and I love cucumbers. And Nestor loves cucumbers. Like whenever I would cut him up, I would always give him the ends, and he would just be so happy that he got those cucumber ends. And now, um, I'm not buffering, so I think it might be you, humanimal. If you're biggering or buffering, it ain't me, babe. Because I'm watching it on my phone. I keep my phone up so I can see. Anyway, I miss him, and I was making salad the other day, and every time I miss him just at odd times, like making salads makes me miss him. I miss Nestor. Also, good morning, Humanimal. It's good to see you. I don't have a drink or a food order, Sissy's mom, but thank you. Kristen, I agree. Boho Hobo says, Jen, I'm 60 years old, live alone, and 2 years ago moved to a tiny apartment in the city, and I love it. I also can't get another dog because I don't want to go through the loss again. I just can't do it. I just can't do it. It's just too much. I will say, though, that I have the Walmart Plus app, and I get Paramount Plus for free through that. But that's like their basic plan. And I'm going to say it's totally worth the $5 more to have Showtime and no commercials. So, oh, I'm sorry, Boho. Boho says, I lost my precious chili dog in 2016 and I still cry. Yeah, it's just hard. Teacup says, we got rid of cable and now I just subscribe to streaming services on Amazon whenever they have deals. That's a good idea too. Like, I know when we moved into this apartment, and I think the complex has like a deal with, hold on a minute, let me just turn this back noise down. They have a deal with, or a contract or something with Spectrum. They were really trying to get us to get Spectrum TV, and I was like, bruh, no. It's not weird, MK. MK says, this may seem weird, but when I lose a dog, I grieve that more than losing a person close to me. Yeah, because in my opinion, dogs represent to me, animals in general, really, cats and dogs, both, represent to me unconditional love. They love you unconditionally. And while as human beings, we are capable of loving unconditionally, it's usually our children that we love unconditionally. So we can, be loved unconditionally by humans and love unconditionally. But by and large, it's a small percentage of people in your life that either love you unconditionally or you love unconditionally. But animals love unconditionally. And I don't know. I just can't, it's a loss. And I miss Nestor all of the time. But I will tell you this. Given how cold it was this winter in the part of Texas that I live in, and it's such a drastic change from Florida, I think one of the reasons that Nestor lived as long as he did, to be as old as he did, given the fact that he is a lab, and a large lab at that, and they usually don't. You get usually like 10 to 12 years. But if due to moving him to Florida as he started to get older, I think really helped him avoid getting arthritis and just all the things that come with old age and being in a cold environment. He didn't limp just until I'm talking about like the last maybe 6 months is when he started getting like arthritic and stiff and having a hard time. Maybe not 6, maybe like the last year. But I think if he would have been, first of all, that drive from Florida to Texas would have been so hard on him. And then to be here during the cold part of the winter would have been really hard on him. And so, yeah. It's just hard. It is, MK. It's hard to get over the little things that, dogs and cats have like little idiosyncrasies the way that we do. They have they have their own little personalities. They all come with, some sort of baggage, all of them, like humans in that way. And what's interesting is that you'll never see a dog or a cat use their baggage or their past experience as a justification for what they're currently doing. That is one thing that separates them. But it's just, you just miss those little things, like, okay, Mac has decided that there is going to be now a toll in the hallway and a toll coming in from the back patio. He sits right up against the sliding glass door with one hand up against the glass. And then when you open the door, you get a snarky look because obviously you've moved his hand, and that is just rude. And then you're like, Mac, scooch, bro, like, let me come in. And he just looks at you. And you guys have seen Mac. He's a big cat. And when he's laying like that, it's like a wall of cat, and he won't move. So you have to step over him. Okay. Then in the hallway, he lays in the doorway between, of of our bedroom, I should say. And he will not scooch. He's in the middle of it. His face is facing the hallway and his back is in the bedroom. He lays at the threshold and won't scooch. So you have to step over him. And also, he wakes up every single morning when I get up, follows me into the kitchen, and starts yelling at me because through the course of the night, even though it's a gravity feeder, he has eaten a hole and can now see the bottom of the feeder. And that is a problem. Now, all he would have to do is stick his little hand in there and hit it, and more food will come out. No, 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 no. Mac's hand is not for getting his own food. That's what Mom's hand is for. And he will not stop yelling at me until I do it. He just has all these little things about him that endear him to me. And I love all his little idiosyncrasies. Yeah. Yes, Leslie. Yes. Will not move like they are the beneficiary of your insurance. Yes. Yes. Will not move. This morning, because I was like, Mac, I've had my eyes open for 2 seconds. Let me start the coffee. Let me get my 5-hour. Stop playing. There's a hole there because you obviously have had food. So it's not like you're about to, your blood sugar is so low that you're about to pass out. You're not going into ketoacidosis. Just stop. Okay, I'll be there in a second. Because I didn't do it on Mac's timetable, what he then did was run in front of me. But he runs in front at an angle so that if you're not paying attention, you will trip over him. And he does act like he's the beneficiary of my life insurance policy. It's ridiculous. Oh my gosh. You know, they say that dogs have humans and cats have staff. And that to an extent is true. That is true. Everybody knows though that the true boss of this household is Alice the cat. She runs the show. She absolutely runs the show. You know, and they're happy to be in the place, to be in our new place, although they're a little bit like, it feels like they're not quite settled yet, because even though some of our stuff is here, they know not all of our stuff is here. And it's like they're waiting for all of the stuff to be here before they decide where all their different little spots in the house are going to be. So there's that. Oh, let me see. Let me put MK on the screen. All right, hold on. Oh, Apollo. He's beautiful. Oh. MK Leon. He's a handsome boy. Uh-oh. What's going on? Are they having trouble getting your client out of the jail? Is he throwing a tantrum? What's happening? Let me see if I can hear. Oops. Oh, of course not. Now they've muted everything. Are you kidding me? There we go. Bruh. Let me tell you something. Teacup says, I had an orange cat. He was polydactyl on all four paws. He was also smart AF. He used his thumbs to get into everything. He would knock on doors and meow hello. There is something inherently special about an orange cat. My orange cat, Monte, was special in that way too. He just had a special personality. He was just so loving. Conversely, the gray tabbies, there's in my opinion, the stripy cats are like an angel and a devil. Okay. The orange cats, they're mischievous, but they're much more affectionate. They're loving and they're sweet, but they be doing some crazy stuff. Whereas the gray tabbies, they're affectionate, but in a different way. And they just be fucking with folks, frankly. They just do. My sister had a great tabby, Cody. And Cody would sit on top of their armoire and smack my sister's husband on the top of his head. Cody also used to tear up the toilet paper roll so that when you went to unroll it while you were using the facilities, you would just be pulling strips. So it would take you, at least a good hour before you got enough toilet paper strips accumulated so that you could actually use the toilet paper. And then we've all heard about the things that Mac does, being a wall of cat tolls in the hallway. I've never had a tuxedo cat before. Alice is my first, but they're special too. I think they just, I think cats are like misunderstood. People think that cats are aloof and they don't care and all those things, but that's not true. That's not true. They do want to be with their people. You just got to learn their language, and each cat has its own language. Aw, I'm so sorry. So the chicken lady says, my orange cat Lucy is having her back left leg amputated soon. They just found a tumor on her leg last week. I'm nervous about it, but I'm sure she'll adapt better than me. Oh yeah, they're super resilient. Aw. Teacup says, orange cats are so cuddly and smart. I have a million stories about my Sammer. I had him from age 12 to 27. Bestest boy ever. Yeah. They're sweet. They're sweet. Good morning, Tony. I think I might have missed you coming in, babe. Good morning. Does anybody have any insight? I feel so dumb. I could have been doing this the whole time, but I just didn't. Trying to find out what this hearing's about. All right, here we go.
2018 CR 157, State of Iowa versus George Wagner III. The case is set for regularly scheduled appearances. The attorneys of record are still here today, and first issue to deal with is Mr. Wagner's not here, so how does the defense handle this? Mr. Hayes,
Thank you, ma'am. Please, the court, Mark Collins, on behalf of Mr. Wagner. Your Honor, we would formally waive his appearance for this hearing. This is kind of a legal hearing with some arguments that are going to be made, as well as some procedural aspects. We're very grateful that Mr. Wagner was moved to Pickaway County. We were able to see him much more frequent because of that. And we've explained that, sometimes he might be here, sometimes he might not, in general, depending on how many of these status hearings we set. And so he was okay with that concept. So for the record, we would formally waive that. It's my understanding that for whatever reason, he has not even been, no one's there to pick him up yet. So, and since everyone's here, ready to go, including the victim's family, we're fine with waiving that at this point in time, in his presence.
Okay, thanks. Is there any position the state has on that?
Runner, obviously, I believe this is the court's decision if they're okay with that. My only trepidation a little bit is that being a death penalty case, although currently the specs have been dismissed, I think in that situation, you don't know that his appearance can be waived. I think he has a right to be here for every hearing, but I would defer to the court on this.
Okay. I would just want to let you stake out your position.
I'm sorry, what?
I wanted you to stake out your position, so you don't have one to speak of.
Deferring to the court.
Yeah. Something else, Mr. Ryan?
No, Your Honor.
So it's a privilege and a right of the defendants to use or waive. I think he fully can. I mean, the circumstances of the death penalty case, like every case, need to be considered to their fullest extent. So I'm willing to accept the waiver proceeds. We can reconstruct the record if we need. It's how you want to handle it. So I appreciate the fact you want to be productive when it comes down to it, Mr. Collins, Mr. Hayes. So we'll go ahead without it. I sent an email out where I outlined what I thought we needed to do today, and doesn't necessarily have to be in that order because I didn't bring the email. But there are a lot of issues to go with, so I'm willing to, I guess, tip it off. But there's motions from the victim's perspective. So, Ms. Gall, how do we want to go about those? You have a preference?
Good morning, Your Honor. Maureen Gall on behalf of victim TR and representative TR. I don't have a preference. I think based on the defense's response.
Hang on. Now go.
Based on the defense's response, pointing out that there hasn't been a legal finding of TR as a victim, it probably makes sense to start there. If he's not found to be a victim by this court, then he wouldn't have any rights after that. So that might be the best place to start. And that was the most recent motion that was filed.
of us understand that we speak faster than people can write. We don't think about it because it's not our job. I suggested to the court reporter anytime she needs to stop the whole thing, she will.
All right, just wave me down.
So when Mr. Collins hands her papers while you're talking, it gets a little overwhelming. But we all do it inadvertently. No big deal. Did you get all that from everybody?
Yes, sir.
Thank you. So there was a response from the defense. We'll just take it in that order. You're welcome to go first with your motion with regard to victim designation.
Okay, Your Honor. Thank you, and may it please the court. So I guess procedurally, it might make sense to go through how we got here. Judge Corbin did issue a decision denying the defendant's change of venue request back in November of 2023.
Were we on victim's representation?
Yes, but they raised the issue in their response to change of venue,
I
so
know,
I
but
wasn't sure.
I asked you to talk about the victim representation, not change of venue.
Okay.
Thank you.
So the victim definition under Ohio Constitution, Article 1, Section 10AD, and Revised Code Section 2930-01H is an individual who is directly and proximately harmed by the criminal offense. Victim TR is the brother of a deceased victim. In this case, Chris Roden Sr. I do believe that the murder of his sibling does cause direct and proximate effects and harm on him, both emotionally, psychologically, and then there's the financial aspect. He has, taken the time to drive to and from court, to attend these hearings throughout all of the defendant's cases, but most recently this one, he is here today. He's taking off work in order to be here. These are ongoing effects that are going to continue to affect the way he lives for the rest of his life. There are several courts in Ohio that have upheld the victim definition in a very broad circumstance. They've held that banks are victims. They've held that an Uber driver not identified in an indictment was a victim. They've held that a law firm was a victim. And most recently, the 5th District did uphold a victim definition for parents, siblings, and nephews of a deceased victim. So I would submit that he does meet that legal definition as a victim directly. As far as the victim representative portion of this, there is no law that I'm aware of that requires this court to designate a victim representative. So I would ask the court to take judicial notice that he is acting as a victim representative in this circumstance. I do have some updated victims' rights request forms that I can file with the court where victims in this case have designated him as a victim representative. I think notably it's important that we look to revise code section 2930-02 that allows a victim to exercise their rights with a victim representative or have the victim representative exercise those rights on their behalf. So taking judicial notice that he's acting in that capacity does not dilute any other victim's voice in this process. Thank you, Your Honor.
Thank you very much. I'll come back at you, but go ahead, Mr. Hayes.
Your Honor, we leave it up to the court's discretion if TR is a listed victim in the case. We're not taking an objection to that at this juncture of time. I think it's within the court's purview and within the court's discretion. We do take into account, and we briefed it, so I don't need to go through everything with this. If they have standing to argue this and if they have standing to argue against the change of venue, we believe that they do not, and the statute doesn't provide them that standing to do that, so we object on the record based on that. But whether TR is a listed victim, we leave that to the court's discretion. However, we do object to the standing that they would have to argue motions to be part of the proceedings.
Which is why I cut her off early.
I'm sorry?
Which is why I cut her off early when she went the other direction. Back to you, Ms. Cole.
Your Honor, in response to standing, victims do absolutely have standing to assert their rights and challenge any denial of their rights.
What are their rights?
They have the right to be present, the right to be heard,
What are their rights?
They have rights under the Ohio Constitution.
I understand.
Article
What are they?
Section 10A. You want me to list all of them? I don't have them in front of me, but they have the right to be present, the right to be heard, the right to restitution, the right to object to unreasonable delay, the right to fairness and respect for their safety, dignity, and privacy. They have the right to an attorney, but not an appointed one, and that's under the revised code section. I think that covers all the rights that I would assert here today. The three that we would be asserting here today are the right to be present, the right to be heard, and the right to dignity and respect for their safety, dignity, and privacy.
Yeah, the right to confer with the attorney for the state, and I brought up previously that the state doesn't represent the victims.
Correct, Your Honor, I would agree.
Essentially, the state's attorney represents the state and talks to the victims, doesn't give them advice, doesn't owe them a duty, right?
Correct.
Yeah, there's 10 enumerated rights. You did a fine job checking them off.
Thank you.
But to steal Mr. Hayes' thunder, I don't know that you represent the state any more than the state represents your client, correct?
I do not represent the state. I am not a prosecutor.
That was your point, right, Mr. Hayes?
Yes.
Okay. Is this the first request, Ms. Gall? Like, I didn't read the whole file. In this case, was there a previous request to designate TR as the victim's representative?
No, Your Honor. I only brought that to the court's attention based on the response and the change of venue motion from the defense.
Okay. Like, I only started this last June, so, and you got here after that.
Yeah, I didn't come in until December, so
But
I'm behind.
Like, in your experience, has there been a deprivation of your client's 10 enumerated rights?
Your Honor, we appealed the change of venue decision from this court based on the argument that they were not heard at that hearing about how a change of venue would impact their right to be present. And the Fourth Appellate District said that the decision we appealed was not final because the venue had not yet been changed, and so they couldn't weigh in on anything else.
Yeah, and they went farther than that, actually, to discuss what you're allowed to participate in, Mr. Hayes' standing argument. I'm just going to want to know if Ms. Canepa is going to cede you the right to talk about her objection to changing venue. So let's put you on the spot and let me know if you consider her now representative for the state to argue the motion that you oppose.
Your Honor, yes. The state's interests align with the victim's interests in this.
Yeah, but that's not the same as ceding representation. So I need to know if she's speaking on your behalf.
What? Obviously she's
I
not.
didn't ask you. I want
Jesus. Here we go.
I know you have opinion, but I need her position.
I think it was, I think it's tricky, I guess, because this court has made it very clear that the state does not represent the victim's rights. And while I did make those arguments during the change of venue, some of those arguments, the hardship that this created on the victims and basically operates as an exclusion of them from the hearings. Because of those hardships, it was our understanding from the court's position that if they wanted to be heard on that matter, they needed to have their own attorney asserting those rights for them. And that's when Ms. Gallup became their attorney, so that she could directly represent their interests. Again, I feel like it's still a state argument, the hardship on the victims, the hardship on the witnesses, all that stuff. So to the extent that her arguments are our arguments,
That's alignment. I agree that you're aligned on your expectations and goals and philosophy. But mine's a question of representation and whether her speaking is you speaking. Her legal duty to represent a client is your duty to represent a client.
representing the prosecution of this case. But again, I mean, she is representing the victim's interest, which we also believe we are supposed to be asserting. So, I know I'm not answering the question.
Yeah, and I'm not sure if it's a lack of knowledge or inconvenient, because it's a huge deal with regard to who represents whom. Like, I don't want to hear a lawyer speak for some other party because they can't. The way you can't represent the victims, in my opinion, is the way the victim's attorney can't speak for the state. I have to look at one table and realize there's different clients. I do it all the time, so do you, with regard to multiple defendants in trials simultaneously.
So give this lady a trial and a table. Hold on a minute. Hold on. I got to stop him. Well, then if the issue is where this attorney that's representing the victim is seated, then pull a table to the middle and put her in the middle. Because asking the prosecuting attorney if the victim's representative attorney represents the state is ridiculous. Just out here playing games. Bruh.
This line, she's going to want to speak on reconsideration of a motion. And I got to decide if I'm hearing you when her mouth moves legally.
Well,
No, you don't. Hold on a minute. Back the milk truck up. Oh, he's getting me so out of control. These are two separate issues, okay? Angela Canepa does not want a change of venue, and she has reasons for that. The other attorney who's representing victim TR also is opposed to change of venue, but for different reasons that are specifically about one specific victim. Although Angela Canepa agrees as it pertains to all of the victim's family members. Get out of here. Oh my God. All right, let me be quiet.
Supportive arguments in this matter.
Yeah, but now we're back to the waffling. Go ahead. It's a first of all, like, there's a lot of discussion in the judiciary about the new rights that are co-equal to the defendants because of the Constitution. We're all getting used to a law that we thought we knew, but we're watching it being expanded and contracted and explained. I put in my routine regularly now that the state doesn't speak for the victim, nor give them advice. And if they have the wrong impression, it's their wrong impression. There's no legal duty. No victim's allowed to sue the prosecutor for bad advice.
Right. No, I mean, obviously Ms. Gow represents the victims in this case. I mean, that is
Period. Only.
Period.
It's a big period. It's a big only. Right? Would you agree?
I believe so, yes, because there may be times where her position is different than the state's.
Okay, I don't think this is hard, but it'll get hard when we start applying concepts.
Yeah, and again, and that's what I was talking about, kind of that trick bet, because while I would be happy to carry the torch for the victims, this court has made it clear that I cannot. But in order for them to...
No, the law makes it clear. I'm just
Okay.
delivering the law.
Okay.
It's not a discretionary item. It's a huge deal.
Okay.
Because I get abuse of discretion thrown at me when in fact I'm just speaking what the law requires me to say.
Yeah. But then in order for the victims to be heard and there to be any real meaning to that requirement, they have an attorney and she needs to be heard.
And as far as I know, I've got to ask her again, she's had that opportunity. Like, I try to acknowledge her every time she's gotten here and invited her to sit in the front when she chose to sit in the back. So there wouldn't be the impression it's a lesser relationship. implementation of their rights, because if he's designated victim representative, do I pull another table? Do I offer you another table and you get the choice? Like, I'm not trying to step on anybody's rights. I'm
What?
trying to get it right.
Hold on a minute. What are you actually talking about? You act like we're having a discussion about place cards at the Thanksgiving table. Who's going to sit at the adult table and who's going to sit at the children's table? Get out of here, bro. This is not what this is about. Stop playing. Stop wasting time. This is absolutely ridiculous. Are you going to designate TR as a victim? That's the first thing. Then moving forward, after you, whether it all is going to depend on whether you decide you're going to designate him as a victim. If you designate him as a victim, then he has the right to be heard and he has the right to object to a change of venue based on how it will inconvenience him because he's a victim's representative. Get the hell out of here.
You have to talk to me about what you think's going on, and then I have to decide if it's the right application of the law. Okay? So, like, run it through your list of things and understand is, do you want your victim representative sitting at council table or not, if I designate that? Go. Yeah, go ahead.
No, Your Honor, that's not something that I'm asking, and I don't think that's something that victim TR wants. I think he wants to sit with the
Yeah,
family.
thanks, that helps me. But if in 4 months you came back and I never asked and you didn't request it, I get second guessed.
Your Honor, not by me in that circumstance. I would like to make a clear record on who I represent, though. I don't represent the state's interests. I have I didn't in my motion, my written motion, and I won't here today make arguments for the state. My sole purpose as the legal representative for victim TR is to make sure that his voice is heard, and the effects of a change of venue would implicate his right to be present at trial. There are hardships that the entire surviving family would see from that, and that's all I'm here to present today is that victim perspective. I don't think that there was an opportunity for that in the last hearing, and the appellate court stated in their opinion that appellant didn't ask for that. They weren't represented at that time. I don't think most victims would stand up and object in a courtroom in the middle of a hearing, and I think that's an unfair assumption or expectation on the victim. So all I'm asking is that you reconsider the decision you made with voices from the victims, specifically explaining to you the hardships that would be put in place by a change of venue.
Equally unfair is for somebody sitting at council table to impute to the court knowledge of something that was never raised. And that's why I asked specifically, has there been an occasion where the court inadvertently or intentionally violated any of your rights, any of your client's rights, any victim's rights? Like, I want to know about it so I can not do it again because nobody said anything, so therefore silence is acquiescence until the second guessing shows up. Like, it happens all the time. I don't find fault with it, but if it's judicial second guessing, like, I don't want to get hung with that again, ever. I want to learn. So that's the segue then, is if I designate a victim representative and we have an opportunity for a representative to speak, who do I ask to speak? The victim representative or anybody who's related and is a victim. Like, did I just lessen rights by designating a victim representative? Because I said there's one victim and the other 5 people that have a right to speak, in my opinion, now don't. So you want to chew on that since you did the segue? You
yes,
want other people to speak, right?
Yeah, so the law says that a victim can exercise their rights on their own or with a victim representative. So the law supports that all 5 of those victims in your hypothetical situation would be able to speak.
Yeah, I'm going to give that. I'm going to give them that.
Okay.
Let's understand, I'm not trying to limit your rights.
Okay.
But I don't want you to inadvertently tie my hands by asking me to designate, right? And then all of a sudden you find out that you closed a door that I didn't think should have been closed, and I'm stuck with it. So I don't intend to limit anybody's rights. At the sentencing hearings, people spoke their minds forcefully and appropriately, right? And we're going to do that as long as it's appropriate. I just don't want you to inadvertently limit what I think is appropriate.
Yes, Your Honor.
Okay?
The
Go.
victim's rights request form allows victims to designate a victim representative, and so and that victim representative can receive notice on behalf of them.
Talking about this.
Yeah,
right?
so that would be my argument submitted, is that even if this court did take judicial notice as that TR is acting as a victim representative, that doesn't tie anyone's hands as far as the rights that other victims can exercise on with him or on their own.
The problem with forms is they imply things they don't mean to imply. Because here they list a victim, singular, and then below it they say victim representative, which I think means an advocate or a lawyer. Like, I'm not intending to limit anybody's rights, but if the defense hears a lot of things that they think are damaging and wants me to say they don't qualify as a victim, then I got to get my hands wrapped around what you asked for and whether they're right. I don't have this form. You have a victim rep. They get one very damaging statement, not 5 or 15, right? Like, I don't tend to be narrow in my application of victims' rights. But if you close and tie my hands, then that's on you, not on me. Like the whole concept of invited error.
Yeah.
Still.
Strategy, right?
No, it's not strategy rights, it's substantive rights.
Okay.
It's because you represent TR, right?
Yes.
Well, what about all those other people? Do you represent them?
I don't have an engagement letter with each victim in this case now.
See where this goes? Like,
But
who's the next victim?
That's why I'm asking that this court take judicial notice that he is representing the interest of
Well, I
many
think so.
victims. I think all of the victims in this case are.
Look, Judge Hein, this isn't that deep. It's not that complicated. She's just said it now for the third time that the victim, TR, has been designated to represent the Rodin family's interests. That's all of them. They all don't want a change of venue. It's just that only one of them, TR, has actually filed something. But he or she speaks for all the Rodin family. What is your freaking point? You rat think? Get to it.
Are in alignment with, moving this case forward and hopefully achieving justice. I think is.
But if they're not aligned, how many victims, lawyers do I get? 5 if there's 5 victims?
Well,
9?
I only know of 3 in the whole state, so I don't know if you get 5 or not. We have to find some more.
I'm not finding them, but they have the right to get their own.
Right.
Right?
Yes.
Alignment's a really cool thing until it's not.
Correct. But I think as long as they are in alignment, a victim representative can voice that alignment and that interest on behalf of many individuals that are unable to attend each and every hearing for whatever reason, whether it be health, school obligations with the orphaned children, and I don't want to get into an argument.
No, this is healthy discussion. Like,
Okay.
this isn't argument.
Okay.
It's argument, but it's not argumentative.
Right.
I
That's
let
what
Miss
I meant.
Canepa come at me.
Okay.
And some people thought it was like disrespectful, when in fact I found it engaging. Like, she raised her voice, but I wasn't offended because it was a heated, passionate issue. Like, would I let her do that again? Yeah, as long as she was professional and like engaged, didn't take it to a personal level, and she didn't. Like, that's that's what we do in this room, right? If you don't have like a firm conviction in your position, just get out. Just don't demean the judge or the system or take it personal, and we'll all get along fine.
We're all on the same page.
Wait till you have to tell one of the family members that you can't listen to them because it's not consistent with your client's position. And good luck figuring out what to do, because Ms. Canepa faces that, Mr. O'Brien faces that risk all the time when they have to figure out who they listen to when they're just giving information, right? Been there, done that. I got this t-shirt. I got the scars on my back when the victims turn on the prosecutor. We just sort it out. Like if anybody says easy today, they don't understand what we're doing. Okay, do you have anything else on the victim representative issue?
No, Your Honor, I don't believe so. Not at
On that issue, like I'm gonna give you a chance.
not on that. Yeah, not on that point.
Mr. Hayes, you want to like jump in here? You don't have to, but
Judge, just reiterate our previous points. I don't believe they're a party to the action. I mean, victims have a right to be present in the courtroom. Nothing that this court ever ruled, and the ruling on was November 25th. They released that. Nobody's ever barred them from the courtroom. They have a right to be present. That right is always been for the victims.
yeah. Thank you. I appreciate your position. Ms. Canepa, Mr. O'Brien, like I haven't asked you if you want to make a record, talk on the thing.
On the victim.
Yeah, like on this last discussion we had, Ms. Gall.
Yeah, and it's my understanding, I don't know if Ms. Gow brought this out, I think she may have, but there are a number of other victims present who have signed a form saying that they want TR to be their victim representative. So, you know, to our knowledge at this point, there's no victim that is not in favor of him being the kind of spokesman. So yes, and I would say, you know, the court's decision certainly substantially impairs the victim's rights, we believe. And so we would believe they do have standing at this time to at least present considerations for the court.
So the decision on designating a victim's representative is deferred pending today, so I'll get you a decision. I'm not just going to announce from the bench. Like I hope you did hear me say I'm not interested in limiting victims' rights and don't want to do so inadvertently. Okay?
Can I just add one thing, Your Honor? Just per the law, and defense didn't offer any, I don't think this court has to interpret any law, and they can just take judicial notice that he is acting as a victim representative. As far as the victim definition of TR, though, that is a legal finding that this court would need to make, and it would implicate whether or not we have any rights when it comes to the change of venue. So I'm not sure whether the court plans to hear or determine standing at this point in time.
I'm going to let you explain how victims' rights articulated in the Constitution crash into the change of venues rules. I'm going to let you argue that.
Okay.
I'm not going to concede that you have the right to. That's the standing defense put up, right?
Correct.
And if I find you don't have standing, I just ignore everything you said, necessarily. But if I don't hear it, I don't know what I'm doing wrong, right? Like there was a pretty good argument with.
Okay, so for those of you guys who are not familiar with this case, back in 2016, 4 members of the Wagner family conspired and carried out a plan to execute 8 members of the Roden family. The issue at hand, the reason, the motive for this was that the son, Jake Wagner, and one of the Roden family members, Hannah Roden, shared a child together. And she said that she would never sign custody of her daughter over to the Wagner family. She had at the time been in a new relationship and had a child from a relationship after Jake, but before the new relationship. She just had a newborn. She'd just given birth. Okay. In the middle of the night, the Wagner family goes over to the Roden family property Billy Wagner, who is the defendant in this case right now, lured the father, Chris Roden Sr., out of the home where Jake and George Wagner were supposed to open fire. Jake's gun jammed, forcing Billy to then take his firearm, get Chris Wagner back inside his home, where he then executed. They then proceeded to go to the next home where Chris Roden's ex-wife, son and daughter resided, where they executed every one of them. And went to the next home where the Chris Roden's son and his wife and their 2 children also resided. And they executed all of the adults. The only people that survived this execution were the children. So there was a toddler, a baby, and a newborn. 3 children survived. They then drove a quarter mile down the road to the final home where they executed the 8th and final victim. This case took an incredibly long, they weren't even arrested until 2018. It's made its way through the courts. It's at Jake Wagner and Angela Wagner both took plea deals. The plea deal included their testimony at George Wagner IV's, who's the oldest son of Billy and Angela Wagner. His trial took place in 2021. In order for the state to remove the death penalty, Jake and Angela both had to testify at that trial and testify truthfully. George Wagner was found guilty and sentenced to life without the possibility of parole. Okay, moving forward, Billy Wagner, the father, is the last person to come up for trial. Been a lot of legal wrangling back and forth. Again, in his trial, Jake Wagner and Angela Wagner were supposed to testify against him. But this judge, who is seated because the presiding judge retired, had decided that he was going to go ahead and sentence Jake and Angela Wagner. That whole hearing you can find on my channel. It's part of the playlist that goes along with all of this. That's why we don't like him, because he doesn't give a rat's fat kneecap about victims or their rights or anything else. He's a jerk. That's it. That's all. That's the whole synopsis as best as I can give. I have a trial playlist of George Washington Wagner IV's trial, plus all the hearings pertaining to Billy Wagner. And if you want to catch up there, but let's get back to hearing this ridiculousness.
With regard to not agreement, oral argument with regard to whether change of venue is appropriate or not. I wrote a decision. Everybody's welcome to like it or not like it. It's not the job. But then I apparently didn't hear enough of your perspective. So I'm going to hear some more of your perspective, which does not imply anything other than I want to hear. There's a motion, but it doesn't necessarily imply that you have standing. Just want to know what I don't know. Make sense?
Yes, sir.
Have at it.
Okay. So just procedurally, I think it makes sense to make a clear record of how we got here. In November of 2023, Judge Corbin issued a decision denying the defendant's change of venue request without prejudice. In September of 2024, the defense filed an amended motion for change of venue before this court after Judge Corbin had retired.
So do you want to put evidence on, or just your argument proper?
So I do not have one of the victims that would like to be heard here today due to school obligations with the orphaned children. So I have 3 statements that I would like to read into the record and submit as exhibits. I did notify the defense of that. I'm not sure whether there will be an objection or not.
Good to know. What do you think, Mr. Hayes?
Judge, one, I'm not sure who these letters have been from, if they're from TR or from some other parties. We've never seen the letters, never been provided the letters. Just briefly before the hearing today, indicated she had some letters, wondered what our position is. So at this point in time, we would object.
So you want to recess?
No.
Okay. Do you have copies that you might be able to show?
I do, Your Honor. I have 8 copies of each for the court and defense and state.
So are they like marked with numbers?
Not as of now. I can identify them as exhibits if the court would like.
Oh, I don't like to. I have to. If you're getting ready to introduce to the record something the court reporter needs to be able to identify. So call them victim 1, 2, 3 or victim ABC or whatever it is you want. Put a date below it.
They are each dated as letters, April 25th, 2025, but I can write the date on here too.
That'll work.
Okay.
Hold on a minute.
Sure.
I'm going to rewind that. I want you guys to see what he just did.
Sure. But I can write the date on here too.
That'll work.
There it is, right there. That was not a facial tick. That was not on an accident. That was a wink. This is disgusting.
Sure.
So let's take a recess, standing break,
Oh my God.
run away off the record.
I wasn't sure. I just got each.
Emily's got it.
And I know that I'm testy today, and I know that I am not my usual jovial self. The reason I'm frustrated, the reason why I'm irritated, and I can't hide that in my tone, is that this judge does not give a crap about the victims in this case. This was an entire family executed. Okay? Jake Wagner took Hannah Roden's newborn child and put that baby up to her breast so that it can continue to breastfeed after he executed Hannah. She was 19 years old. This was brutal. This has taken a long time to get to trial. And this judge, in one fell swoop, by giving Jake and Angela, by sentencing them, he tied the prosecution's hands. They got the deal they got because they were going to testify. Then, to add insult to injury during sentencing, he gave Jake a chance at parole, and he admonished Angela Wagner, because she was the only Wagner family member not present at the scene, okay? But she was in charge of holding on to the other Wagner's cell phones to make sure that it appeared as if they were home when they were in fact not at home. And he admonished her and said she had every opportunity to stop this and she didn't, so it was her fault. This judge is disgusting. He's not, and listen, I don't want the judge to be biased either way. I don't want the judge to rule too much in favor of the state, and I don't want the judge to rule too much in favor of the defense. The judge is supposed to be the umpire. Okay. If this were a baseball game and the ump was constantly calling strikes when there wasn't a strike, it would be an issue for all of us. We'd all be, yeah, this is no different than that. He's supposed to be the referee applying the law, and he's not. And then to see that wink, and I saw that wink. I'm livid. I'm absolutely livid. This was the most expensive investigation in the history of the whole entire state of Ohio. The Wagners left the state of Ohio for a hot minute, went all the way to Alaska while being investigated, which made the investigation into the crime even more expensive because then they had, I'm just frustrated. I'm sorry that I'm spicy. I'm sorry that I'm yelling and out of control. Let me just let me take a moment. I'm going to harness my chi and get back to being somewhat professional.
Yeah,
Emily's got, you got,
Did you give the judge?
no, not yet. I wasn't sure.
well, like, hang on, because
I'm
arguably,
approaching, we're not on the record.
yeah, but arguably, you could say I'm not supposed to have those. No, get it?
Am I supposed to have it yet?
Yeah, so we're going to.
Put it down there, okay, 'cause that's the record. No, I don't want to, like. A 10-minute break to organize the documents, so Ms. Gall, you're on the record, go ahead.
Your Honor, we've already addressed standing. You said you would make a decision. So moving on to change of venue, the victims have the right to be present and heard any time there's a public proceeding and any time their rights are implicated. With relation to the criminal offense, their rights are absolutely implicated by a change of venue. We are,
Which right is implicated?
Their right to be present. It's substantially impeded by a change of venue, specifically based on distance. We are not aware of what county this court is changing the venue to. And so had they addressed the court back in October, what they would have presented is that some of them have taken in the orphaned children that are now of school age and have to get on and off the bus every day. Some of them are blue-collar workers who can't afford to take off for a month. One individual...
Is that not the case in every criminal matter? Like whether you drive to Waverly or whether you drive to Hamilton, is it not the same implication? It's an inconvenience to have to come to downtown Waverly if you live in the northwest corner of Pike County.
Absolutely, it is, Your Honor.
Okay, so how do I sort out when the rights are violated? Does like just geography, like 25 miles is reasonable and anything over, is there an objective standard?
Your Honor, I think the right here is the right to be heard. Victims have a voice in the process, and these three statements explain what the effect would be of a change of venue, which is why I asked to proffer those in as exhibits. TR is here and willing to take the stand if you'd like me to direct examine him on the effects that this would have on him specifically. I wasn't going to do that. I was going to let the statement speak for itself. But he specifically speaks for his mother, who's also an 82-year-old elderly woman with health issues. And so, yeah, moving this out of Pike County would just be unfeasible. And it doesn't offer an opportunity for them to exercise the right to be present.
So does the defense have, first of all, you had a chance to look at the three exhibits, right?
Yes.
Okay, so do you you have a position, Mr. Hayes, with regard to the court being made privy to the contents of the material as evidentiary matters?
As an evidentiary matter, no. I think the court can take it into consideration, but whatever way the court deems appropriate.
It doesn't cash in or concede the standing issue, like I said.
Correct.
I want to state the obvious.
Correct. Just like a bond hearing, the court can take in other factors and other issues, so no objection based on that.
So I'll consider the substance. I'm never going to tell who to call. Now, never's not fair. I rarely call my own witnesses. So if you have witnesses, then you're welcome to call them. I'm not telling you to call them.
Yes, Your Honor.
I'll take the letters, though.
Prefer not to. I would move to admit exhibits V1, V2, and V3. I can also read them into the record.
No, just give me the 3, because Mr. Hayes has conceded that I can consider the substance. It doesn't concede the standing. So,
Madam President.
yeah, thanks. Assuming, of course, you think that the letters don't violate the client's rights.
No, Your Honor, the letters do not violate the client's rights. It offers them a voice in the matter, and I do concede with the defense that it's the judge's discretion, it's the court's discretion to weigh this matter, and all of the evidence presented. Again, I want to clarify that what I represent is the victim's interest and their voice in this process. They did not address the court in November, and that's why we're asking for a reconsideration of the court's decision. They do, in the Constitution, it says that their rights should be protected in a manner no less vigorous than the defendants. Defendants have to waive their right to be present at trial, whether that's in writing or on the record orally. Here, there's been a lot of choice and choose wording in both the defendant's arguments and in their written brief response. And, I would proffer to this court that there is no choice. If this moves outside of this county, that takes away their choice. Like I said, there are children involved.
Do you now understand why I will not let you not appear? You said you were entering a limited appearance, but you wouldn't go to trial, and I refused that. So you have to show up. Do you understand why?
Your Honor, I don't know that this court has the
Oh,
authority.
no, I totally do. You entered an appearance. I'll stop talking when I'm talking. With all due respect, you don't get the option to not show up, because everything you're talking about that's so important has to be represented in the moment, not after the fact. If anything, I made a decision without you here that you later complained about. And I didn't even know was going to be the grounds for a complaint. So understand, it's in the record, now it's from my mouth, that you don't have the option to not show up. Every call of the court means you're here, period. I'm going to remind you that I have the authority to make your life very difficult for not honoring that order. Because this is too important for you to opt in and opt out, to say when you think you're needed and when you're not needed, because these are big issues in my world that can't go unanswered at the moment. So if you're not here, you have a problem. Because this is so important, you don't get to opt in, opt out at your choice. Got it? There's nobody in this room has an option as a lawyer to show up or not.
Your Honor, respectfully, I disagree. I think that
I don't want to cut her short, but I need to know what you guys want me to do. We can and will come back to this. They've resumed testimony in Karen Reed. So if you guys want to finish this, we can finish this and then go to Karen Reed, or we can go to Karen Reed now and finish this later, but I need to know what you guys want me to do. I'll keep playing the rest of this argument until you guys tell me what to do in the chat, because I'm here for y'all.
the contract that I signed with my client is for limited appearances.
That's fine.
We have 3 attorneys for the entire state. We don't have any funding for me to sit in a month-long trial. I cover 13 plus counties for the state, so that's just unfeasible. I also have a family in Cincinnati, so.
It's a really good record to make. It's a really good record to make.
Yeah.
All of which I can't care about. Because what you just said applies to every other lawyer in the room. And me.
All right, so we're going to pause it there and go over to Karen.
Job 6 months ago. I am the Chief of Pathology and the Laboratory Medical Director at Signature.
And where did you work prior to your work at Signature about 6 months ago?
Prior to that, I was at Good Samaritan Medical Center in the same capacity.
And how long did you work at Good Samaritan for?
Since 2015, late 2015.
And did you work in any capacity similar to that prior to working at Good Samaritan?
Prior to Good Samaritan, I worked at the Kearney Hospital, which is in Dorchester. Started that job in 1996. So I stayed on staff at Kearney Hospital up until actually closed 6 months ago. So I've been on staff at Kearney's for quite a long time.
Where did you go to school and what degrees did you receive?
I went to college at Tufts University in Medford, graduated in '87. From there, I went to Tufts Medical School and graduated in 1991.
And following your graduation, where did you go from there?
After medical school, I did a residency at Tufts Medical Center in 1991 to 1996.
And then where did you go following your residency?
And right from residency, my first job was at Kearney Hospital, which I previously mentioned, so 1996.
And doctor, are you board certified?
I am board certified in anatomic pathology and clinical pathology.
And what is a board certification?
Board certification is something we need to show that we are actually qualified to perform the job that we need to do, both in anatomic and clinical pathology. It's a written exam that we take and we need to pass. To demonstrate that we're competent and know what we're doing.
First, in just general terms, if you could explain to the jury, what is pathology?
Pathology is, there are two basic branches of pathology, anatomic pathology and clinical pathology. Anatomic pathology is basically an anatomic pathologist is a physician or MD or a DO trained to make diagnoses on patients via looking at tissue biopsies, organs, tissue fluids, and we're also trained in autopsy pathology as well. So basically, an anatomic pathologist, we look at tissues via glass slides. Slides are made. And we, every day, make the diagnosis of, somebody has a cancer or somebody doesn't have a cancer, benign, look at colon polyps, breast biopsies, pretty much anything that comes out of the operating room or a physician's office, any sort of biopsy. Clinical pathology, on the other hand, is basically a clinical pathologist is a physician, an MD or a DO, who specializes in the clinical lab, which basically is any fluid specimen, including blood specimens. When you go to the hospital and you have your blood test and it gets sent to the lab, the clinical pathologist is ultimately responsible for the quality of your lab tests and quality, and basically that's it.
And so the time that you worked at Good Samaritan, did that cover the date of January 29th, 2022?
Yes.
And again, what was your title and what was your job at Good Samaritan in the month of January 2022?
I was the Chief of Pathology at the time and Laboratory Medical Director.
And what did you do as the laboratory medical director?
Laboratory medical director, basically, the laboratory medical director is responsible for the ultimate quality of any, either whether it's a biopsy, somebody's biopsy, or lab result. The laboratory medical director has to make sure medical director has to make sure that the final result is of excellent quality. So there are many different things that we need to make sure that things that are in place, as far as need to make sure we have the correct amount of workers. You want to have enough workers. You want to make sure they're competent. So as many, there are policies for competency. For all the lab techs and phlebotomists and even pathologists. So basically the laboratory medical director, if something goes wrong, it's ultimately his or her fault.
And the lab at Good Samaritan, is that lab accredited?
Yes, it is.
And by what body?
We are accredited, or Good Samaritan is accredited by the, we call it the CAP. It's a College of American Pathologists. They are considered the preeminent accrediting body for hospitals. They've been around for probably 70 plus years or so.
What is accreditation? What does that mean?
Accreditation is basically something that says that your laboratory is following guidelines and providing excellent quality. To be accredited with the CAP, every 2 years we have a laboratory inspection. They don't tell you when they're coming. They will give you a 3-month window, and they'll come and inspect you. To make sure we have a good quality lab. Each section of the lab, pathology, the clinical lab, microbiology, chemistry, hematology, the CAP has a checklist with numerous requirements that one needs to fulfill. There are probably over 3,000 items that they look at.
And was your laboratory at Good Samaritan, was the accreditation up to date on January 29th, 2022?
We were accredited. Still are.
Now, in Good Samaritan Medical Center, when a blood test is ordered, what types of things is the lab testing for?
I think the most common tests that are performed when you go and you have your blood tests is one is chemistry, a chemistry test where we sodium, potassium, chloride, glucose. We also a common test is a CBC, or a complete blood count, where we look at your red blood cells and your white blood cells and your platelets. Those are the two most common tests.
And why is blood testing ordered in the course of medical treatment at a hospital?
When you're admitted to the hospital, usually you're sick, so the physician is usually a standard, ordering chemistry and CBC to see if there are any clues in those tests that could help the doctor take care of you. If they look at a BUN and creatinine, maybe if they're elevated, you either could it be dehydrated or have renal failure. If you look at liver function tests, maybe there's something wrong with your liver. So it's just a general, a good look at the patients to see if there are any clues that could help them.
And as far as the blood testing results are concerned, how does that assist either a doctor or a clinician in treatment and diagnosis?
Basically, what I just said. If there's nothing, if the results are normal, that sometimes helps too. Rules things out if they're normal. If they do a CBC and look at the hemoglobin and it's low and patient's anemic, maybe the patient might need a transfusion. So there are many different case scenarios where the results can help the provider, the clinician.
Now, with reference to alcohol, does the Good Samaritan Medical Center, do they also test alcohol within the blood?
Yes, we do.
And why would that assist medical treatment and diagnosis?
I think if a physician is wanting to know if somebody's been drinking or has alcohol on board, or maybe not, maybe that patient has ingested maybe drugs of abuse. So they'll test for alcohol to see, one, if it's positive, and if it is, then it helps confirm that the patient has been drinking.
Now, are there any policies and protocols at Good Samaritan Medical Center with reference to how blood is taken and how blood is tested?
Yes, we have numerous policies. We have one policy specifically for phlebotomists. Those are laboratory technicians who draw the blood. So we have a policy for them to explain exactly what they need to do. And also in the laboratory, we have numerous policies basically for any tests that we provide. And so we have a policy for alcohol testing as well.
May I approach the witness, Your Honor?
Yes.
Doctor, I'm placing before you two sets of documents. Just ask you to review those generally and look up when you're finished. And do you recognize what those are, sir?
Yes.
And can you explain to the jury what is contained within each of those two sets of documents?
Okay. The first one is a patient preparation for specimen collection. This is the policy that I was mentioning, specifically designed for our phlebotomist to detail the procedure of the blood draw. Basically goes through one of the most important parts of the process is correct patient identification, where we need to correctly identify the patient. We have the patient state his or her first and last name and state it out loud to make sure it matches the patient that we're trying to draw. And then we also match up the bracelet to the medical record number on the patient's bracelet. So one of the most important things is correct patient identification. The rest of this policy goes on and just pretty much details what to do next, including finding the veins, cleaning the site. It has some information on if there are any complications. So it's basically the entire process of the blood draw. The second one is our alcohol policy, which pretty much details in detail what goes on behind the scenes for an alcohol blood test in our hospital.
May I approach again, Your Honor?
Yes.
Your Honor, Commonwealth will seek to introduce and admit as the next two exhibits.
All right, thank you.
Your Honor, for the record, it would be the patient preparation for specimen collection, the next exhibit in line.
All right. Exhibit 35.
And the ETOH policy would be the next exhibit number 37.
Thank you. Exhibit 36.
Excuse me.
That's
Thank you.
Now, doctor, what types of precautions are in place at Good Samaritan with respect specifically to alcohol testing in the blood? Or I should say taking the blood sample from the patient.
Yes, one of the major things we need to do with taking somebody's blood for alcohol is to obviously not use an alcohol swab. Normally, when you have your blood test, they cleanse the area with a swab that contains alcohol. So in our policy is a specific statement that says, do not use alcohol swab, because potentially when you're drawing the blood, if you suck up some of that residual alcohol, you could cause a false positive. So we have in our policy, and it's every hospital should have the same policy, where we use a swab that has no alcohol. We call them a moist towelette. That's what we refer them to. Also, in the emergency room, my supervisor pretty much removed probably 95% of all the alcohol swabs. So just in case a phlebotomist forgets to not use an alcohol swab, they are hard to find. We need to keep a few there because we need to use alcohol wipes on certain tests like blood cultures and stuff like that. So,
when were the alcohol swabs removed from the emergency department?
It was before my time.
So fair to say prior to January 29th, 2022?
Correct.
What is a phlebotomist and what do they do?
So a phlebotomist is a healthcare professional who specializes in drawing blood. So they're the ones who are trained, competent, and know what to do when they draw a patient's blood.
What kind of training do phlebotomists receive at Good Samaritan?
We try to hire phlebotomists who have been trained. It's just easier. So they can have a high school background, but if we train on site, they just need to be trained on the proper protocol, proper procedures, and demonstrate competency.
Is there any sort of proficiency testing related to phlebotomists at Good Samaritan?
There's no proficiency testing for phlebotomists, but there's competency assessments. So with phlebotomists or any laboratory technician or even pathologists, there are strict guidelines for competency. We have to always make sure people know what they're doing, and it's a CLIA or a federal government regulation or requirement. So when anybody first starts in a hospital, the requirements are, one, initial training. You can't let anybody come in on their own, without not knowing what they're doing. So we have to document that they have the initial training and they're competent. And then the law says 6 months from that, we do another competency assessment where we look at 6 elements of competency defined by CLIA, and 6 months from that, 1 year from the start date, is another competency, and then after that it's annual thereafter. And that goes for phlebotomists, and then it goes for any laboratory technician.
Doctor, once the blood is drawn by the phlebotomist, what happens then?
So the phlebotomist will draw it at the time. They need to have the specimens labeled in the patient's room, because you don't want the phlebotomist to mislabel. So everything gets labeled at the patient's bedside with an initialed and with the phlebotomist's initial and date and time. That blood test will then be sent to the lab. In this case, blood was drawn in the emergency room, so it gets packaged into a plastic bag and sent in a pneumatic tube up to the laboratory.
And once it's sent to the laboratory, what happens with the sample from there?
Once we receive it, it's called receiving the specimen. There will be a technician who then goes into the computer, enters the phlebotomist's name from the tube into the computer system, enters the time, and the technologist will look and see what was ordered, and then do the appropriate next step based on what was ordered.
And in a case in which alcohol is one of the items that are ordered, what is the next step as far as the testing goes?
So the next step with alcohol testing, we use a specific tube, so the phlebotomist would know what tube to use. It would be a light green tube that has lithium heparin in it. It's an anticoagulant. We don't want the blood to clot, so that's why we use an anticoagulant. So the first step when testing for alcohol is that the test is designed to be performed on serum or plasma. And to get that, the next step would be to centrifuge the blood. A centrifuge is a machine that spins the blood rapidly. We spin it at around 3,300 RPMs, which is pretty fast, rotations per minute. And the reason why we spin it, because centrifugation will allow it to separate the blood components based on the density. So heavier stuff like the red blood cells will go to the bottom, and the lighter stuff like the watery component of the blood will go to the top, and some of the white cells go into the middle. But for alcohol testing, we are targeting the top part of the blood component, which would be plasma.
And then once it goes through the centrifuge process, what happens then?
So once it's centrifuged, we have the separation of the blood components. We have the plasma ready to be tested, so that technologist will walk the specimen over. It's probably 10 feet from there, and put it onto our Roche Cobas machine. That's our machine that performs our chemistries as well as alcohol testing. It goes onto a machine. All the testing is basically inside of a black box, and the label present on the blood tube will dictate what the Roche machine will test. So based on the barcode label, once it's on our machine, it knows what test to do, and it will perform an alcohol test.
And Doctor, for our stenographer, do you know how to spell that Roche Cobas machine that you were just referencing?
So R-O-C-H-E, Roche, and Cobas, C-O-B-A-S.
Thank you, sir. May I approach, Ron?
Yes.
Doctor, showing you another series of documents. Again, if you could just look at that and look up when you're finished. Do you recognize those records, sir?
Yes.
And what do you recognize those to be?
These are the medical records of Karen Reed.
And, sir, is there an indication within those records as far as the date of treatment for Ms. Reed?
Yes, there's a bunch of dates in here.
As far as the treatment is concerned, sir?
Yes.
And what is the date of treatment?
1/9/22.
Sorry, is that 29/22?
That's what it says on this. Admit date, it says 1/29/22.
Thank you, sir. That's fine. Doctor, if I could direct your attention further into the document to a previously tabbed portion, do you see any indication in there as far as a result for alcohol testing?
Yes, I do.
And with respect to that result, have you reviewed these records prior to today?
Yes, I did.
And if you could explain to the jury sort of the timeline from this blood sample as far as, let's start with first when it was ordered.
So when it was ordered, it was 9:03 in the morning.
Okay. And when was it taken, sir?
The blood test was taken 5 minutes later, so 9:08.
And then what happened, or what is the next time that something of any significance happened with it?
5 minutes from that, 9:13, we received it, and 9:53 in the morning, the result was entered into the computer. So it was ordered at 9:03, and I believe it was 9:53. The results were in the computer.
And may I approach again, Your Honor?
Yes.
Commonwealth to seek to introduce and admit as the next exhibit.
Any objection, Ms. Little?
No objection.
All right, thank you.
Exhibit 37.
Your Honor, may I return to the document?
Yes.
And doctor, what was the result of the testing for alcohol in the defendant's blood when it was taken shortly after 9 a.m. on January 29th?
93 milligrams per deciliter.
Thank you. Nothing further, Your Honor.
Okay. Ms. Little?
Thank you.
Good afternoon, Dr. Fowler.
Oh, good afternoon.
The Good Samaritan lab is a clinical lab, not a forensic lab. Is that right?
Correct.
And hospitals are not in the legal business of calculating an individual's blood alcohol concentration. Is that right?
I would say 99.9% of the time we are not in the legal business. We are testing alcohol for the diagnosis of alcohol intoxication. But occasionally a case may come, very rare, to a hospital, and it ends up being a legal case. It's not common. I think uncommon.
And you'd agree that there are differences between screening tests that are conducted at hospitals and forensic tests that are conducted by law enforcement, right?
Yes.
The purpose of testing in a clinical setting is to assist in the diagnosis and treatment of a patient, right?
Correct.
And physicians need to analyze blood quickly. They need to get the results so they can see what's in a patient's system and then effectively and efficiently treat that patient, right?
Correct.
Whereas in a forensic setting, tests for blood alcohol concentration are designed to produce results that are reliable and credible for use in court. Correct?
Correct.
You testified earlier today that your lab is accredited by CAP, which is the College of American Pathologists. Do you recall that testimony?
Yes, I do.
But CAP is a clinical laboratory accreditation, not a forensic accreditation, right?
We don't have the forensic accreditation for Good Samaritan.
In fact, Good Samaritan has never been investigated or accredited by any forensic accreditation team to ensure that you perform all of your tests with the integrity necessary to support results in court, right?
We've never been, we've never had the forensic accreditation, but we have very good quality lab results, which I could go into further.
But you've never been accredited by a forensic accreditation team, right?
No.
And the lab at Good Samaritan has never been accredited by the ANSI, which is the National Accreditation Board known as ANAB. Are you familiar with that organization?
No.
Are you aware that ANAB is the forensic accreditation body in the United States that ensures that laboratories' procedures meet the minimum standards necessary to ensure results are reliable and credible for use in court?
Objection.
Sustained.
Now, the most reliable method of forensic ethanol testing is called headspace gas chromatography, or HSGC. Are you familiar with that process?
Yes.
And HSGC is the method that's used by forensic labs to test for blood alcohol content, right?
Correct.
And that's because forensic tests require the testing of whole blood for the presence of alcohol, right?
Correct.
Can you briefly, just for the jury, describe sort of the difference between a whole blood test and a serum test?
Sure. So whole blood, to put it simply, when you have your blood drawn, you see the fluid coming out, all red. That's whole blood. We don't do anything to it. We don't spin it down. We don't centrifuge it. That is whole blood. That is the specimen of choice for forensic blood ethanol testing. Hospitals, on the other hand, our methodology, which is just as good as the forensic headspace gas chromatography, is based on looking at the serum or the plasma. So we don't, that's what when I explained that we need to centrifuge it, take the liquid portion off the top. So in the hospital, we test it on the serum or the plasma. Now, did you ask me the difference? You want me to go into the difference?
That's enough, Doctor. Thank you. I'll ask some additional questions to kind of clarify. And in a forensic lab, they actually require the testing of whole blood, correct?
Correct.
And HSGC directly measures ethanol in the blood.
Correct.
And this method is designed to be accurate and reliable for forensic purposes for use in legal proceedings, correct?
Correct.
But the testing in this case was performed using the hospital's clinical chemistry machine instead of a forensically defensible method like HSGC, right?
Correct.
And that clinical chemistry machine performs what you just testified to, a serum test, right?
Serum or plasma.
Serum or plasma. And hospitals use serum or plasma testing because it's actually quicker and more efficient than HSGC, right?
Yes, it's less labor intensive. It's easy to automate, but at the same time, very, very good and very accurate.
But serum testing does not actually measure alcohol directly. It instead measures the presence of what's called NADH, right?
Say that again.
Yes, I'll repeat that. That was my fault. Serum testing does not actually measure alcohol directly. Instead, it measures the presence of NADH. Is that right?
Almost.
Well, NADH is a byproduct of alcohol, right?
Correct. I can go into the testing how methodology that we use to explain it if you want me to.
Well, serum testing measures the presence of NADH, correct?
It measures the rate of change of NADH production, so it doesn't actually look at just NADH, and it measures the rate of production, and I can go into more detail on that. Alcohol testing in the lab is correct.
I'll ask you some additional questions
sure.
about NADH, and we'll get there.
Yeah.
So you can do this now, but let the doctor answer his question fully next question, okay? And the following questions.
Doctor, the higher the NADH in a patient's system, the higher the serum test result, correct?
That may not be correct, no. It's the rate of change of NADH production based on our methodology. I can go into that. So our test system is a little bit different than the forensic testing system, but it's also very good and very accurate, and almost when we compare our methodology to the headspace, we get the exact same results, and when we compare and with peer laboratory comparisons. But what we do is and I think the jury needs to know this. Maybe some of you might understand the chemistry behind it, but we do. We take the patient's sample, and it's based on we add, because when there's alcohol in the specimen, we add, actually, in the test system, alcohol dehydrogenase. It's the same enzyme that's in the patient's body. In addition, we add a surplus of NAD to it. NAD is similar to NADH. They get converted back and forth. So when we put it on our test system, it's alcohol dehydrogenase is in there, and what happens is when there's alcohol, it combines with NAD that we add to it. It creates NADH. And then in our machine, there's a spectrophotometer, which can monitor the rate of NADH production over baseline. And we use, there's something that measures, a photometer that measures the NADH production. It looks at light in this physics and looks at 340 nanometers, and it's pretty accurate. It will monitor. It will tell you, it will tell the system how much NADH is produced, and that amount is directly proportional to the alcohol in the patient's sample. So it's a very, very accurate test. But there are some limitations that I can go into.
So wait for another question.
Okay.
Next question, Ms. Little.
Yes, so serum testing can be subject to errors, right? And there are limitations.
There are some limitations that I can explain, just like headspace gas chromatography may have some limitations too. But I can go into them.
Next question.
What are some of the limitations of the serum testing?
Okay. So the serum test, as with many tests in the laboratory, different things can interfere with our laboratory tests. And the three most common ones, which are unlikely to affect ethanol testing, is we abbreviated HIL. We want to look at those three things. One is hemolysis, which is H, and the other one is I, icterus, which is high bilirubin, and the third is L for lipids. High lipids will interfere with alcohol testing or with any testing based on that same methodology. Our machine, the Rose-Kobash machine, and all the machines out in the market today are very sophisticated. If we have elevated levels of any H or I or L, it will flag it and raise the potential for a problem. The next thing on the list is that our alcohol testing is not absolutely specific for ethanol. There are two possible other alcohols that can cross-react. One is propanol and butanol. But then it goes clinical history. Did the patient ingest those two alcohols? And third is there's some unusual hematologic malignancies like Waldenstrom's macroglobulinemia. That can interfere. So it's always have to correlate with the clinical situation. The next one, sometimes there can be patients who make endogenous, make their own alcohol. So very rarely, some patients may truly have a positive result. That could be from our test or Headspace. They make their own, so we have to rule that out. It's a rare condition. And the next one is one that's in the literature, which is LDH and lactic acid. If a patient has a markedly elevated LDH or lactic acid, those one is an enzyme, and the other one is an acid. That can cause false positives. Now,
If I could stop you there, Doctor. I think those were the four that you identified, the four limitations: the lactic acid, the hematoma.
Yeah.
If I could just
Go ahead and ask your next question.
If I could ask you a few more questions about LDH and lactic acid.
Sure.
You're aware, Dr. Fowler, of the medical literature establishing that the presence of LDH and lactic acid can lead to falsely elevated serum readings, correct?
Correct.
And that's because lactic acid, or LDH, actually forms NADH.
Lactic acid, I'll have to go into a little bit of chemistry. Lactic acid and LDH, lactate dehydrogenase, they both act on each other. And LDH and lactic acid needs NAD plus to break it down. So in theory, when you're testing a serum, a plasma for blood alcohol, if there's extra LDH or high levels of LDH, high levels of lactic acid, you add it to the test system, and then Roche throws in, or Siemens throws in the NAD, it will form NADH. That was first documented, I think, back in the older versions of these ethanol testings back in the 1990s, when they stumbled on, they were looking for biomarkers or reasons in kids with SIDS, little babies, and they found that two of these babies had a positive alcohol. But
Doctor, if I could just ask the next question, if that's okay.
Sorry.
So in other words, NADH, studies have found, can actually be formed by certain biomechanical processes other than the presence of alcohol, right?
Yes.
Are you aware that the National Institute of Health has found that liver diseases, kidney diseases, muscle injury, trauma, and even anemia are some of the health conditions that can lead to a rise in serum LDH levels?
Yes.
Are you aware that Ms. Reed was severely anemic in January of 2022?
Sustained.
Are you aware that the medical literature has also found that patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls?
I'm going to allow that.
I haven't read anything specifically related to the NADH level, but but I want to go back to the point where our laboratory, our testing is not based.
Let him finish his answer.
It's not. It's the rate of change of NADH. So if somebody has NADH on board, I believe it's not going to affect the result. It's the rate of change, and it basically, back to the anemia. I haven't read or heard of that.
That was stricken. That was not allowed.
It all goes back to the lactic acid and the LDH. The NADH doesn't matter. So looking at multiple sclerosis patients, they can have elevated LDH and lactic acid, but it's not to the extent that it can interfere with the alcohol levels. There was a study maybe 7-10 years ago.
Your Honor, there's no question pending.
You asked him about a study, if he was aware of the studies.
I asked, and that's a yes or no question. And he's...
All right, Doctor, we're going to hold that there for you and ask the next question.
Doctor, have you reviewed the August 21st, 2013 peer-reviewed article entitled Serum NAD Through Disease Course in Multiple Sclerosis, which was sponsored by the Center of Healthy Brain Aging by the University of New South Wales? Which...
Can you do that again and slow down, please?
Sure. Doctor, have you reviewed the August 21st, 2013 peer-reviewed article entitled Serum NAD Levels Through Disease Course in Multiple Sclerosis, which was sponsored by the Center for Healthy Brain Aging by the School of Psychiatry at the University of New South Wales in Sydney, Australia, which specifically found that patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls?
Objection.
I'll strike the part of what the article held. Is he aware of the article?
No, I'm not, to be honest, no.
Dr. Fowler, did you consider Ms. Reed's anemia and multiple sclerosis condition when you conducted the alcohol test on January 29, 2022?
No, we don't, no.
And again, serum tests like the ones conducted in this case don't test for ethanol. They only test for NADH, right?
We test for the rate of change of NADH production.
And Doctor, you did a number of other tests on Ms. Reed on January 29, 2022. You tested for additional drugs, not just alcohol, correct?
Correct.
And all of those results were negative.
Correct.
Thank you. No further questions.
Okay.
Doctor, are you aware, I know your lab at Good Samaritan did not do this process, but are you aware through your training and experience of any sort of mathematical conversion that can be done from a serum reading in milligram per deciliter to a blood alcohol concentration of whole blood?
Objection, Your Honor.
I'm going to allow it. The door is open.
Go ahead, sir.
Yes, I am aware. Yep.
And please describe what you're aware of with reference to that.
Well, with blood alcohol concentrates goes to, when it's in your blood, it goes more to the watery components of your blood. So when I described the process earlier, whole blood is before we spin it. And when we test the plasma, which is specifically testing the watery component. Now, people have done studies like how much percentage of water is a serum versus whole blood. Basically, to put it simple, there's a higher percentage of water in the serum versus whole blood. So a hospital result will always be a little bit higher than a test on whole blood. It can be, I think the ratio, the conversion factor is anywhere from 1.1 to 1.18. It's always could be 18% or 11% higher in serum versus whole blood. But we don't do it. That's what I read. I will defer that to the experts.
Now, Doctor, you were referencing in your cross-examination about a study that you were aware of about 10 years ago or so regarding MS and alcohol testing. Is that correct?
It was more on MS, looking at the results of lactic acid and LDH to see how high the levels of lactic acid can go in a group of multiple sclerosis patients. When reviewing that, we found that the range went from some normal range, 16% of the multiple sclerosis patients had normal lactic acids, but the remainder had elevated levels. But those levels were not anywhere near the required levels to produce a false positive. Our package inserts and for the Roche testing system, the Roche has it's an FDA-approved test, and they have to do in-depth, detailed testing before they allow any hospital to do a test. And they have listed levels of lactic acid beyond which the test would not be reliable. But the results, based on this study of 600 multiple sclerosis patients, 2 big centers in Italy and 1 in the Netherlands, show that the highest level of lactic acid in the MS patients did not achieve, didn't get close. Usually patients with MS that are asymptomatic can have normal or low normal levels, or slightly elevated. It was the ones that had more symptoms that had elevated levels up to, I think the highest was 6.5 millimoles per deciliter, which is not high enough to interfere with our result.
Now, with respect to the lab at Good Samaritan Medical Center, the interference that you were speaking about earlier on cross-examination, what would happen if any of those types of interference were to occur during the course of the testing?
No, I'll allow it.
The three main ones, which I detailed earlier, is the hemolysis, icterus, and lipemia. Machines are sophisticated. It will detect it and say, it will flag it and say, please do not result it, or we'll have a disclaimer saying, interpret this result with caution. The results may not be accurate. And it hardly ever happens with alcohol testing. But if it did, we would get a result like that, and we probably wouldn't report it.
And from your review of the defendant's medical records, specifically her testing from January 29th, did you notice any interference or any reports like that in her record?
No.
Now, the testing that you're doing at Good Samaritan is in relation to patients such as that might have cancer or heart disease or something like that, correct?
Correct.
Now, you were talking or started to speak on cross-examination about the good quality lab results that you have from your lab, and you wanted to go into that further. Could you please expound upon that for the jury now?
We have you mentioned proficiency testing before. So all hospital laboratories accredited by the CAP or have to participate in proficiency testing. What that means is that every 3 times a year, and they give us 5 unknown samples. And we have to test it, report it back to CAP, which also reports back to the government. And we have to basically get the correct answers. And with alcohol testing, it's probably one of the best tests in the laboratory. Always have right on the money results. But at the same time, we're also able to look at results of all the other labs that participated in this proficiency testing. So we can look at different methods. We can look at labs that had the same method as us to see how we're doing. And usually with this proficiency testing, we have 3,000 labs across the nation that have the same methodology as us, so we can compare to them. And also, interestingly, we can see the labs that are using headspace gas chromatography. And out of interest, we can see, how do we compare? And we have exactly the same results on these proficiency testings. We also look at some statistics as well, not going into them, but we can look at some stats like standard deviations and SDs. And actually, the hospitals with enzymatic testing have slightly better stats with that compared to Headspace. Pretty close, but a little bit better.
And doctor, from your review of the defendant's medical records and the blood testing in this case, was that done in conformity with the policies and protocols at Good Samaritan?
We have policies in place to be followed, and there's no reason not to think that somebody didn't follow policy.
Thank you, sir.
Anything else, Ms. Little?
No questions.
All right, doctor, you are all set, sir. Thank you. Do you have another witness, Mr. Brennan?
I do.
Okay.
The Commonwealth calls Jason Becker.
Okay, so while we're waiting for the next witness, I have to say that, look, I think even Karen agrees that she was intoxicated that night. I don't think that's up for debate. I think the defense did a good job mitigating those circumstances, but to me, I didn't find his testimony compelling as to guilt one way or the other. That's just me. All right, here we go.
Good afternoon, sir. All right, Mr. Bennett.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please introduce yourself to the jury?
My name is Jason Becker.
How old are you?
I am 36 years old.
Do you live in the area?
I do. I live in Canton.
Tell us a little bit about your education.
My education, high school and college UMass, and I went to EMT school a little over 10 years ago, and paramedic school.
Tell me a little bit about EMT school. How old were you when you started EMT school?
When I started EMT school, roughly 21 years old.
Why did you decide to go to EMT school?
I wanted to save some lives.
Tell us a little bit about EMT school. What did it require?
EMT school is a couple months of classroom stuff, and then you do some ride time on the ambulance. Paramedic school is a little different. It's about a little extended. 2 years worth of training. You're doing hospital, ER time, and ambulance time also.
How long did you serve as an EMT before you went to paramedic school?
I worked as an EMT for approximately 5 years.
Can you estimate how many dozens or hundreds of calls you were on during that time?
Hundreds.
Why did you decide then to go get paramedic training?
Oh, I wanted to be on the fire department, and it was a prerequisite.
Did you complete paramedic school successfully?
I did.
Were you still working as an EMT at the time?
I was.
And inevitably, did you seek to have a different job? Did you try to be a firefighter?
I wanted to be a firefighter, correct.
Were you successful in doing that?
I was.
Tell us a little bit about that, sir.
On the Canton Fire Department. So I got on the Canton Fire Department, and then they send you to the fire academy, where you train to be a firefighter.
So you had EMT training, paramedic training, and then firefighter training?
That's correct.
On the Canton Police Department, did you serve dual roles as a paramedic and as a firefighter?
Fire department?
Yes.
Yes, sir. Yes, sir. Firefighter and as a paramedic.
You served as a firefighter and a paramedic?
Correct.
In the Canton Fire Department, does it have more than one station?
There is. There's two.
Is there one station that's larger or smaller than the other?
Station 1 is the headquarters, which is larger.
Had you ever spent time at Station 1 as a firefighter or a paramedic?
I have. We rotate through both stations.
I want you to take us back to January 29th, 2022. Were you working that evening?
I was.
What station were you assigned to?
Canton Station 2.
Canton Fire Station 2?
Correct.
And that's the smaller of the two stations?
It is.
Were you working with anybody at Fire Station 2 that night?
My ambulance partner at the time was firefighter Dan Whitley.
Was there anybody else who was working at Fire Station 2 in addition to you and Dan Whitley?
Correct. There was an engine company with 3 guys on it.
3 people were assigned to the
engine, correct. Yep.
Were you and Dan Whitley assigned as partners for the day, the week?
Correct. Yes, we were.
Which was it, the day or the week, sir?
The week.
So for the entire week, you're partners with a person, and does that rotate on other assignments?
It does. It rotates.
So on this particular week, you were assigned as partners with Dan Whitley?
I was.
What were your roles between the two of you?
Well, at the time, he was my preceptor. I was a new paramedic at the time. So I was more or less the lead tech on all the calls as part of my training. And Dan's been a paramedic for a long time, so he was there to teach me.
So would Dan Whitley be the lead on the call, and he would help you?
I would be the lead.
You would be the lead?
Correct.
Did you get a call that early morning hours of January 29, 2022?
We did.
What was the call assigned for?
It was a call for Section 12 psych eval.
Very briefly, can you tell us what a Section 12 is?
Sure. It's a transportation order filled out by police, doctor. Basically for us on the ambulance that we have to take the patient whether voluntarily or involuntarily because they're a threat to themselves or someone else.
When you received the call for Section 12, were you aware that there were other calls that Fire Station 1 had responded to that morning?
We were aware. You can hear the calls going out each station.
Were you or Dan Whitley any part of that earlier call that Fire Station 1 responded to before you got the call for the Section 12?
We were not.
So your efforts were after?
We were after, correct.
After you got the call to respond to a Section 12, did you head towards Fairview Road?
We did.
Tell us a little bit about the trip to Fairview Road.
It was a little extended because of the weather conditions at the time. Snowing heavily, windy, low visibility.
Okay. How long did it take to get from Fire Station 2 to Fairview Road?
Approximately 8 to 10 minutes.
Who drove?
Firefighter Whitley.
Now, on the way to Fairview Road, do you sit in the front of the ambulance?
We do.
Take us to when you arrived to Fairview Road. What do you see?
You see a bunch of police lights. Canton Engine 3 was already on scene, so we parked behind them.
Did you have it, without talking about what you spoke about, did you have a chance to speak to anybody at the scene?
We briefly spoke to the Canton police, and they briefed us and sent us to where the defendant was at the time.
Why do you have a conversation with other first responders at the scene before you do anything?
They're making sure the scene is safe to begin with, and they're on scene first, so they have a little more info than what our dispatch would have.
After you had that debriefing with colleagues, were you directed to approach any certain person?
I was.
Where did you go?
I went to the defendant, who was sitting in a black SUV type car.
Were there other persons inside the car with the defendant?
From my understanding, there was one person in the driver's seat.
And what seat was the defendant in?
She was in the front passenger seat.
Did you have a chance to speak to her?
I did.
And the person you spoke to who was in the passenger seat of that car, do you see that person in court today?
I do.
Could you point out and describe an article of clothing, please?
Miss Reed right there, she's in the blue, navy blue.
How long was your conversation with the defendant while she was still seated inside the vehicle?
Approximately 5 to 8 minutes.
At some point, did you and the defendant move to another location?
We did.
Where did you go?
So we went back in the ambulance.
After having a conversation with her, was she cooperative going back to the ambulance with you?
She was.
And did you ask her to be seated in the ambulance?
I did.
Was she cooperative with that as well?
She was.
After she was seated in the ambulance, did you close the doors and get in?
We did.
When you say we, who was with you?
Me and Firefighter Whitley.
So you and Firefighter Whitley were in the back of the ambulance with Miss Reed. Who was going to drive the ambulance?
Firefighter Sam Park.
Where did he come from?
He was on the fire engine that was already on scene.
I want to ask you questions now about what you did in the back of the ambulance and some of the conversations that you had. Tell us what your role is once you have a patient in the back of the ambulance. What do you do next?
Each patient's different. Depends on what the call is for. In this specific situation, it was more a psych eval, because that's what we were called for. Initial triage questions: is the patient cooperative, uncooperative, combative? I asked her name, her mental status, where she was. I asked her if she was suicidal, and if she was, did she have a plan? Did she want to hurt anyone else? Those are kind of the initial triage questions that I would ask.
Why do you ask those questions?
Just to get a kind of a judgment on the patient, reading the patient.
What's your role at that point? Are you an investigator?
I'm not.
Are you in any way law enforcement?
I'm not.
So what's your focus when you're speaking to a patient?
It's basically hearing them speak in their story. In this specific situation, we didn't know circumstances. We just knew that Miss Reed had found her husband, which she was calling dead on the side of the road. So it was a traumatic call.
So when you were there, you knew nothing about what had happened before you got there?
We did not.
And your role had nothing to do with any of that investigation?
We did not.
You were solely focused on caring for the patient?
Correct.
Did you have any other role other than caring for the patient?
Just making sure she got to the hospital safely. She didn't hurt herself.
During those conversations, are you and Firefighter Whitley doing the same thing or different things?
Again, it depends on the call. I was the lead tech, so I'm the one documented, giving a report to the nurses, the staff. So I was more kind of getting that information, my initial triage questions, and then just kind of sat and supported Ms. Reed. And
Were you writing down information, technical information about status and health on a report?
I was, yes.
While you were doing that, was your colleague speaking to Ms. Reed?
He was.
Did you have a chance at times to hear what they were speaking about?
Yeah, and no.
At other times, did you speak directly to Ms. Reed?
I have.
Can you describe her demeanor or temperament?
Initially, she was agitated because she didn't feel like she needed to go to the hospital. She said the statement she made, she didn't mean. She just kind of said in jest because of the events that she went through. So she, but then there'd be periods of which she'd be calm, and then it would fluctuate. She would have like pressured speech, repetitive, but all in all, she was cooperative.
At some point, did you have a chance to speak to her directly about her mood?
About her mood?
About her mood.
I don't know if I understand the question.
Okay. Did she say anything to you about her last interaction with what she referred to as her husband?
Objection. Sustained.
Did she make any statements to you when you were giving her treatment or speaking to her about her husband?
Objection. I'll allow that. It came in.
One of the reasons why she was saying suicidal stuff is because the last conversation she had with her husband at the time was an argument. I didn't feel like it was my role to really find out the details on what was said. But that's what she said to me.
That the last thing she said to him was an argument?
Yep.
Sustained.
Did she tell you what the argument was about?
She did not.
Inevitably, did you get a chance to bring her to the hospital?
We did.
Did you stay in the back of the ambulance with her?
I did.
Did you continue to have conversations with her?
Yes, I did.
Did you hear conversations or parts of conversations she was having with your colleague?
I had parts.
When you got to the hospital, what happens next?
So we brought Miss Reed into the hospital, registered her, bring her to the psychiatric section. Is it?
Okay. Thank you. I have no further questions.
Okay. Mr. Jackson?
Thank you, Honor. I have just a moment, Your Honor.
Yes.
Good afternoon, Firefighter Becker.
Good afternoon.
When you first arrived at the scene, there was at least two Canton police officers there, still.
Correct.
Do you remember their names?
Officer Saraf and Officer Mulvaney.
Okay. Their cruiser was there. You said that an engine was still there?
Correct.
And was there another ambulance there, or the other ambulance had already left the scene? They'd cleared?
They had already transported to the hospital.
Remind me, you were in ambulance 2?
I was ambulance 2.
Got it. You parked behind the SUV where you ultimately made contact with Miss Reed, correct?
I think it was more in front of the SUV because the way the SUV was parked.
Got it. Got out of the ambulance, ultimately made contact with Miss Reed through the passenger door?
Correct.
Had a short conversation with her there?
I did.
You said it was maybe 5 to 8 minutes?
More like 5 minutes because of the weather conditions.
Okay, nothing of great consequence. I'm guessing just an initial, I think you called it sort of a triage assessment?
Well, it was more of just introducing myself and asking her how she was doing.
Got it. And then there was one other person in the cab of the vehicle as well?
There was.
Female, male?
Female.
So there are 2 females, one Miss Reed, one another female. Did you see any other civilian females out there?
I didn't see.
Okay,
but
so at least where you were, the contact that you had with Miss Reed and this other female, there was just 2 of them, not a third one?
From what I saw, correct.
Did you get the other female's name?
Not at the time, I did not.
Okay. By the way, have you since gotten her name?
Based on a conversation Firefighter Whitley and Miss Reed had back in the ambulance.
Got it. Okay. And who is that other person?
Miss Carrie Roberts.
Okay. When you first observed Miss Reed, did you note whether or not there was anything unusual about her physical appearance, meaning anything on her?
She did, yes.
Describe that for the jurors, please.
She had some blood around her mouth, her neck area.
At that point, were you concerned about, obviously you're concerned mainly about her safety and getting her safely to the hospital, correct?
That's correct.
Were you worried that that might be her blood?
She had said that she had given CPR to her husband.
Okay, you jumped a question ahead. I was going to say, did she tell you that it was in fact not her blood?
She did, so that kind of, in a way, ruled it out.
Okay.
No injury for me.
And you didn't notice anything about her that looked like she was physically injured or physically in harm?
I did not.
Okay. She indicated that she had given CPR, mouth-to-mouth, attempts at mouth-to-mouth resuscitation to Mr. O'Keefe, correct?
She did.
And that would account for the blood on her face and in her hair and on her neck?
That's what she told me.
Okay. And based on your observations of her, you didn't have any reason to quarrel with that?
Correct.
Okay. You indicated that her tone was somewhat rapid and repetitive. Is that right?
It fluctuated. So at times it was, yes.
Did it appear to you at that time that she had gone through a pretty significant trauma, as best you were trained at the time?
Objection. A little bit more of a foundation. I'll give it to you.
Sure. Have you ever, in your course of training, seen individuals who have gone through some sort of a traumatic event?
Frequently.
Frequently.
Everyone's different, though.
Understood. Obviously, everybody's got their own personalities and the way of dealing with those things, right?
Sure.
Have you been able to, through your training, assess whether, at least in your belief, your observations, if someone has gone through a relatively traumatic event, as opposed to just someone whistling down the sidewalk?
Yes.
Okay. Did it appear at that time, when you're interacting with Ms. Reed, that she was showing the signs consistent of having gone through a trauma?
At the time, yes.
Okay. So, hence the rapid speech, the repetitive speech, things of that nature?
Correct. For her. For the defendant, some people don't have rapid, repetitive
Understood.
speech.
I'm just talking about your observations of her at that time.
Yes, sir.
Her demeanor was consistent with having gone through a significant trauma.
For the situation, sure. Yes.
Okay. You said that she went from calmness to agitation. The agitation you accounted for being, I don't necessarily want to go to the hospital, I don't want to be sectioned, correct?
She felt like she didn't need to. It wasn't, she wasn't going to act on her comments about wanting to harm herself.
You called it, I think in a report, it's SI, suicidal ideation?
Correct.
That's obviously of great concern to you and your partners when you're assessing the patient, correct?
That's right.
You don't want to leave someone on their own if they're going to self-harm, correct?
That's correct.
You pretty quickly assessed, I'm guessing, Firefighter Becker, that she was not, in fact, in the position to self-harm, that I think you said that the statements that she originally made, if John dies, I don't want to live, were not necessarily at the level of actual suicidal ideation. Is that right?
Yeah, I mean, at the time I believed her because of the information we got and what she went through.
I'm sorry, I didn't quite understand your answer.
Sorry, can you repeat your question?
Of course. It's probably my fault. At the time that you assessed her, even though she had made some comments about if John doesn't live, I don't want to live either, you did not elevate that to the level of her being suicidal at that moment.
So I couldn't rule it out, but
okay.
I didn't think it was a huge threat at the time.
Understood. That's what I was trying to get at.
Couldn't rule it out, so that's why we had to take her to the hospital.
Understood. I mean, you had a Section 12. You had to take her irrespective of what you ruled in or out, right?
Right.
Okay. Firefighter Whitley was with you in the back of the ambulance the entire time you were with Miss Reed, correct?
Not the entire time. He was before we decided transporting. He was kind of in and out, trying to find more of, talking to the police officers, find more of a story of, what happened,
okay.
why we're taking the defendant on a Section 12.
Once you and Miss Reed were in the back of the ambulance, firefighter Whitley then joined you in the back of the ambulance?
He did.
How much time lapsed?
It was a couple minutes at the most.
Okay, so it wasn't a lengthy amount of time.
It wasn't lengthy.
And he was with you during the transport, along with Miss Reed, for the whole transport back to Good Sam?
Yes.
And you said on direct examination, I think your phrase was, all in all, she was cooperative with us.
For the majority of the transport, yes.
Okay. Never became combative, never got physical, nothing like that?
No.
Okay. She did refer to Mr. O'Keefe as her husband or her spouse?
That's correct.
You're aware of HIPAA rules, obviously. You're in the medical field, correct?
Correct.
You were aware at the time that HIPAA rules would demand or dictate that unless you're a spouse or a parent or a child, there are certain rules against getting or providing information to someone who isn't one of those close family members, correct?
That's correct.
Okay. You previously indicated on direct examination that, I think your words were, that Ms. Reed indicated that her last conversation she had with her husband was an argument, correct?
Correct.
You've previously testified about that statement in other particulars, right? Other hearings.
I have.
You're paraphrasing. You didn't write down what she said about her previous interactions with Mr. O'Keefe, and you didn't record those on a tape recorder, correct?
I wrote down in my report that she said she had an argument.
Right. You didn't write them down at the time. That was a bad question on my part. You weren't taking notes as she was speaking.
Yeah, it could have been. I mean, it's kind of for every call we jot down notes on a notepad, just
Okay.
so when we give the staff a report, we can read off it.
Do you have those notes?
I don't.
Okay. Do you think you took notes or no?
To be honest, I'm not sure. I could have been typing them on the computer. That's what we typed the report on.
Okay.
At the time.
Do you have an independent recollection of taking notes, either handwritten or on a computer, as you sit here right now?
I couldn't tell you if I did one or the other. Sometimes
Okay.
I write on the computer, sometimes I don't.
Or you might not have written anything down, correct?
Correct.
Okay. So, in any event, you weren't taking down, even if you were taking notes, you weren't taking down verbatim quotes of what she was saying. You were paraphrasing the information that was coming to you, correct?
That's correct.
All right. You had previously said or testified that the last time, let me rephrase that just a little bit. You previously indicated in recounting what it was that Miss Reed actually said to you was something along the lines of she was upset because her last words to him were because of her last words to him being in anger.
I object.
I'm going to allow the question.
Is that correct?
Well, I probably phrased it a little wrongly. The last words. It was the last conversation.
Okay, that wasn't my question. My question is a simple one. In a previous hearing, did you use the phrase "her last words to him"?
Yes,
were
I
in
did.
anger?
I did.
And that was at a hearing where you're under oath, just like you are now, correct?
Correct.
That was a little closer in time than we are now. It was maybe a year ago, correct?
Correct.
Actually, my mistake. It was about 2.5 years ago. It was a grand jury, correct?
Grand jury was before. Yes.
Okay. And the phrase that you used was, and I want to concentrate on that for just a quick second, Firefighter Becker.
Sure.
The phrase that you used at that time was that she said, quote, like her last words to him. She was upset about her, quote, last words to him. Is that right?
I object.
All right, can I see counsel at sidebar, please?
Hey, you guys. Okay. I don't know. I need to know because it matters under these circumstances, to me anyway, how it came to be that Karen was sectioned in the first place. So, because obviously we're not going to get that, I don't think, from Becker or Whitley because they were called after the fact, right? They're called to transport Karen. So we're not probably going to get that story from them. But I need to know under what circumstances it happened. Who did she say this to or within earshot of? and who reported it. That's what I need to know. We probably did get that in the first trial, but Cash, I don't remember it. And I'm looking at the second trial very differently than I am the first. And I'm just curious about that because I do think it makes a difference, because I wonder if they had Karen sectioned so that perhaps there was even more time to get a timeline put together, as it were. Hey, Violet, good to see you, babe.
May I continue, Your Honor?
Yes.
Thank you. When you were recounting the conversation that Ms. Reed indicated that she was upset about, you also indicated, in addition to using the phrase, her last words to him, you also said that it was earlier in the night, correct? They had an argument earlier in the night.
I don't recall.
Well, yes, Cash, that's also true, and I do need to be patient. It's a developing skill, one of those things I'm just not quite great at. And I'm sorry, Jen, I know that's got to be hard.
May I approach?
Yes.
Thank you.
Thank you.
If you don't mind, take a look at the top paragraph, very, very small print. Let me know when you've refreshed your recollection.
Yes.
Okay. May I approach?
Yes.
Thank you, sir.
You got it.
When you wrote your report, you had indicated that when she was describing the argument that you testified to on direct, it was about an argument that was, quote, earlier in the night.
Earlier in the night, correct.
Okay. And then you recounted that statement, that same statement in the grand jury later on as at least including, quote, her last words. Is that right?
Her last words.
You were talking about an argument that they had, and then she was upset, and you were paraphrasing her, and one of the things that you paraphrased was, in fact, your statement was she was upset that was like her last words to him, correct?
She said that.
Yes.
Correct.
Okay. Were you also made aware, did she tell you that her last words to him were in voicemails? Did she say that?
She didn't give any details.
Did you ask her?
Thank you.
What were your last
Nicholas,
words to him?
I appreciate that.
I did not.
Did she ever say whether or not she believed he ever received her last words to him?
There was no other details there was no other details other than what she said.
Okay. But she did, when she was having this conversation with you about her last words to him, she did actually take out her phone and show you a bunch of missed calls to him at the same time, didn't she?
She tried to, yes.
Okay. In your mind, did you put two and two together that what she was actually talking about were the missed calls and her being upset about her last words to him, being very angry on those missed calls, those voicemails? Did you put those two things together?
I didn't.
Okay. Thank you. That's all I have.
Okay, Mr. Brennan.
Sir, when Ms. Reed told you that she was sad because her last conversation, or her last thing that she had said to him was an argument, did she ever suggest that was in a voicemail?
Objection.
Did she ever suggest it was in a voicemail?
She did not.
Did she ever suggest that she didn't actually speak to him, but instead it was some type of message?
Objection.
I'll allow that.
Did she ever suggest that?
She did not.
In fact, you wrote a report saying that there was an argument earlier in the night, didn't you?
Objection, Your Honor.
Sustained.
You then were interviewed, weren't you? Were you
Yes.
interviewed on February 14th, 2022?
Yes.
And you referred to the fact that she told you there was an argument earlier in the night?
Argument early in the night.
Okay. And she was telling you this when you were speaking to her that morning?
Correct. Around 6 a.m.
Right.
Yes.
And earlier in the night, do you know if she was referring to 12:30
I did not know.
or 12:15
No.
or midnight?
I didn't know the time.
So his answer is he doesn't know.
You testified in the grand jury, and Attorney Jackson just asked you some questions about part of the statement you made to the grand jury when he said, like her last words. Would you like to put that in context of the whole statement you made? Do you remember
her last words?
Do you remember the entire statement that you made in the grand jury about the statement that was made to you?
I'd have to.
May I approach?
Yes.
This is page 81, lines 1 through 4. Please read it to yourself.
Right here, sir.
1 through 4, please.
Yes. Right.
Now, when you made that statement you were asked about in the grand jury, you didn't just say, like her last words, did you?
No.
No. You explained your memory to the grand jury?
Objection.
Ask him what he told the grand jury.
Okay. The grand jury, do you know it was on April 21st, 2022?
Yes.
Okay. And did you tell the grand jury? So she
I'm going to see counsel at sidebar for a second, please.
My God, we're having a sidebar. My goodness. All over what Karen Reed said. Look, I can't really fault this paramedic or EMT for not digging deeper into this conversation that Karen's alluding to in the back of the wagon, okay? Because truth be told, their job on the scene that day was to transport Karen, make sure she's stable, transport her to the hospital, and there the physicians would take over and diagnose, test, and treat Karen. So while what she said to them, you know, is I guess it's somewhat relevant. I'm not, I can't get mad for him not asking follow-ups to the things that she was saying.
So I'm showing you that statement that you made that includes last words, but there's more to the statement, isn't there?
She was upset.
I'd like you to read
your
your entire
Sure.
statement, 1 through 5. You can read it out loud.
So she was also she was upset also because she said they had, you know, the last time they had talked, she had gotten into an argument. So she was upset that that was like her last words to him.
And so when you were speaking about her last words to him, were you referring to the argument?
Correct.
You testified again regarding this issue, didn't you, in May 3rd, 2024?
Correct.
Okay. And at that point, did you think or believe that the conversation she was relating to you was about a voicemail?
Objection.
I'm going to sustain the objection.
Did you use the word again on May 3rd, 2024, argument?
Objection.
I'm going to allow this.
I used argument.
May I approach, Your Honor?
Yes.
Can I ask you to read your prior statement on page 10, lines 9 through 13?
Objection.
I'm going to see you at sidebar again and bring these documents, please. Bring all of it.
Yes, bring it all. Beth wants to see you up there at the sidebar. Get up there. See what's going on here. Yeah, see Jason Becker he's not as defensive to me. Really, doesn't seem defensive at all. Much different than Whitley from yesterday. Whitley was very, very defensive and just did not come across the way, like we talked about this yesterday, how when he was testifying, he like acted it out. He did the whole putting his hands, putting his head in his hands and all of the things. And to me, his testimony came across more exaggerative than anything else, which gave me pause because like my father at one point was a paramedic, and then he taught EMT and paramedic school so I remember going with him when he would do this, when he would teach these classes. And I remember him talking to the students about the importance of when you're on the scene, yeah, it's important to be empathetic to the patient and to the patient's family, but you cannot be emotional. You have to compartmentalize. And your job is to assess the situation and stabilize the patient for transport to the hospital. That's what a paramedic's job is. And then they have to be able to, and then the paramedic, when they get to the hospital, they have to be able to relay what happened with the patient on the scene, as well as during transport to the hospital staff. So the hospital staff have a full picture. And to me, Mr. Whitley, the way that he came across was emotional and exaggerative. And it's off-putting to me when you're dealing with somebody that's a first responder. I understand that they're humans. I understand that they have emotions. I've just never seen a first responder actually show those emotions on the stand. If anything, I've seen the opposite. I've seen them come upon some horrific scenes, be called into court to testify about those horrific scenes. You can see that they're getting emotional, recalling the memory of what they saw that day and what had to be done and all of those things, and then fight to keep those emotions in check and not be emotional on the stand. And Whitley was completely opposite of that. And when he was, cross-examined about supposed statements that Karen had made, he got real defensive. And I just thought, wasn't a good look for the state. It wasn't helpful.
May I?
Yes.
Thank you. Sir, when you wrote the report of your notes to put in your report, do you remember the word argument?
I did.
Do you remember her actually saying the word argument?
I did.
Do you remember her ever saying any word about voice messages?
I did not.
Okay. You said that there was somebody in the front seat of the car with the defendant?
I don't think that you're being defensive, Sissy's mom, Jen. I don't. I think that you need to, as a paramedic, as a first responder, as an EMT, as a cop, all of those things, because you're dealing with people who are basically having likely the worst day ever, whether it's the victim or the perpetrator. The perpetrator is going to jail. That is not a good day, period. Guilty or not a good day. Anytime you go to jail ain't a good day. The victim, obviously, clearly not a good day. And I do think that first responders need to be empathetic, but there's a difference between being empathetic and being emotional. And I think that the firefighter or EMT firefighter who testified yesterday, Whitley, came across as not empathetic. In fact, the opposite. He came across as emotional. He came across as pissed because Karen expressed feelings about Carrie Roberts, who he knew. And that tainted everything from then on with him, his experience with Karen, the way that he perceived her.
It was.
And you later learned from the defendant it was a person by the name of Carrie Roberts.
Correct.
Can you share with us the context? How did you learn that?
The defendant and my partner, firefighter Whitley, had a conversation.
Objection.
I'm going to allow it.
So the defendant brought up how if her husband had died at the time, she didn't know how she was going to take care of his kids.
Objection.
I'm going to allow this.
And firefighter Whitley mentioned that she had like a strong support system. You know, all the friends are on Canton, and
Objection, Your Honor. And reproach.
Yes. Okay, now this sidebar, I know what this is going to be about. This sidebar is about the statement respective to Carrie Reed, Carrie Roberts, because Karen said, so one firefighter said, you know, looks like you've got a strong support system. And then Karen responded allegedly with, well, if you knew Carrie Roberts, you wouldn't be saying that at all. To which the firefighter responded, well, I do know Carrie Roberts. And then basically, but the problem with that is it wasn't something that was testified to at the grand jury. So it's hard. Like if that is something that stood out to you and you're being questioned during the grand jury proceedings about conversations that occurred in the back of that ambulance between the paramedic EMT and Karen Reed, you would think that that is something that would come out during the grand jury testimony, but it didn't. That's a problem for the state, not for the defense. So MK says the only emotional first responders on the stand usually are the actual one who discovered a gruesome crime scene of a child or children and are still rare. They usually know how to turn it off. That's exactly. Thank you for putting it much better than I did, MK, because that's what I've seen is that with the Chloe Driver trial, the officer who responded to the scene was testifying and they were going through photographs, or not photographs, his body cam footage. And you could see that as he's testifying and as he's watching this body cam footage, the memory is then coming back and how he felt that day and what he witnessed that day and what he saw that day. And he tried so hard to control that. So hard. I'm starving. My tummy is eating a hole in my back. I don't know what I'm going to have for lunch, though, even though nobody asked me. Violet says, the first responders are not helping the state's case at all. I believe the jury is giving major side eye. In my opinion, they didn't gain any points yesterday or today. They haven't gained any points, actually. I have to agree with that, Violet. I don't think that the first responders who are supposed to be who you would look to, they're the ones that got there first, right? Hence, first responders. They saw the injuries. They saw all of the things, right? And they're removed from the situation. They don't know any of these people, except for in this case, they know all the people. I'm getting that. I'm going to go get that GIF real quick so I can have it for times like this.
When you spoke to the defendant and she shared with you that her last words with her husband were an argument, why didn't you ask for more detail about that?
I didn't feel it was at the time we went about the call as that we didn't think we would be witnesses in a murder trial. We were there to support Karen and ultimately get to the hospital safely.
And you were asked about trauma, and you said that you observed that the person may be in trauma, Ms. Reed.
A traumatic event,
Traumatic event.
Right.
Do you have any idea what caused that traumatic event?
I did not.
Thank you. I have no further questions.
Anything?
Very briefly, you indicated that you were asked on redirect examination by Mr. Brennan whether earlier in the night could have been 12 or 12:15 a.m., correct?
That's what he asked, yes.
And earlier in the night could have been 6 o'clock p.m.
Early in the night, yeah, correct.
Could have been 5 o'clock p.m.
Could have been.
Could have been 7 o'clock p.m.
Sure.
Okay. You were also asked whether or not Ms. Reed actually specifically mentioned voicemails when she talked about those last words. And you said she didn't.
That I remember, correct.
But she did show you her phone.
She tried to.
And she did show you a bunch of missed calls to John O'Keefe, correct?
I wasn't going to look through her phone. I don't know who she called.
Thank you.
When she said about the argument, she said those were the last words, the argument, right?
That's correct.
Sustained. All right. Jurors disregard that last statement. All right, you are all set.
All right. Thank you. Thank you, guys.
Is this a good place to stop for the day?
If the court pleases, yes.
Jurors, we could do 6 minutes, but I think this is probably a good place to start. So, as I understand it, folks, we're on schedule, right where we thought we would be. We're going to release you for today. Now, when I told you this morning, and I've told you other times too, that when you're out in that room waiting for us, we're in here getting work done to make things more efficient for the trial, especially a trial this long. We've decided that we're going to spend Monday afternoon again trying to streamline this trial and deal with issues that we have to deal with. So Monday for you will be a half a day. All right, so I just wanted to tell you that before you left today. Please, again, those 3 cautions: do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it, let us know. And I guess the 4th caution is the same as I've been saying. Please be very careful with your social media. All right, have a good weekend. We'll see you Monday morning.
All rise for the board, please.
And I'd like to see counsel at sidebar, please.
Oh my God. All right. So before we say goodbye for the afternoon, this is Bindi today. Okay, because let me just say this. So we started out this morning, right, with Karen Reed. Not a whole bunch of stuff was going on because they went on a field trip. They went to see 34 Fairview. 34 Fairview Lane. 34, yeah, Lane. I think it's Lane. Just I'm going to leave it there. 34 Fairview. Okay, so we decided to go on over to Ohio and listen in on the Billy Wagner pre-trial hearing, which caused me to lose my whole entire mind, and any pretense of professionalism that I might have had went out the window, down the road, all the way probably another state. Like it left the town, it left the city, it left the county. It's like completely in another state. Hey, I forgot about this. Okay. So that was a problem. Okay. And it was just like a snowball effect from then on. It was just, I could not even behave the rest of the afternoon. Also, MK Lynn, it's MK Lynn's birthday. Happy birthday, MK. Going to sing to you now. Are you ready? Plug your ears. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, MK Lynn. Happy birthday to you. Happy birthday, MK. I hope it's the best ever. And you get treated like the scholar and the gentleman that you are, sir. Well, on Monday, happy birthday Monday. I'll remember Monday too, but happy birthday weekend. Yes, the audio was caca. It was terrible. Oh, I was so frustrated. All right, so let's see what's going on with this sidebar before we end out for the day, because I'm curious. Yeah, there was really no we in the decision making. It was I. I was using the royal we. Ah. Well, of course, I picked up for MK's birthday, Cash. MK's my bud, man. Oh, they returned a pen. How nice. No, the country life of the chicken lady. Chicken lady. This is what I'm going to do. Okay. I'm going to cover the trial or the hearing tonight because I think there are I think that there are people that want to listen to it, and then there are the people that do not want to listen to it. And I need to be able to give Judge Hine the full read that he deserves. I don't think it's fair to deny him all my outrage, and I need to be able to focus. So I'm going to be back at 8:00 Central, 9:00 Eastern tonight, and I will do the whole. I'll do the whole thing because I don't want to miss a minute. This way, I can cover all of it and give all the outrage that this judge deserves, because let me just say this. Judge Hine, the friendship door is closed. We is not going to be friends at all, ever. And because I want to show you guys again the wink, because that is what really went all over me and just caught me on fire. Like, I was enraged at that. And I know that people might say, well, it might have been in the general direction. The wink was in the general direction of the defense table, but somebody could have been sitting in the audience behind there. No. This is not a Monty Python Holy Grail situation where the Kinets fought in your general direction. No, this was a wink at the defense table. That's it. That's all. The end. Oh, so mad. No, you know what, Sissy's mom, Jen, it could have been an option. It could have been an option. I give every judge the respect that they're due because they are the judge. And I do respect the American justice system. But then Judge Hine. And after that, it went out the window, down the road. No. We could have been friends if he wasn't him. Hey, Low Red, good to see you. Oh, it has been. I have been so spicy today. I'm all spiced up. I cannot. I'm sitting here and I'm hearing it right along with you guys, and I'm even shocked that I'm hearing what I'm hearing. I've seen some judges do some things in my time, okay? Covering trials and watching trials myself. I've seen some judges and I've been like, bruh, what? Okay. This is not even a bruh what situation. Like this is not even a bruh situation. It's past bruh. I need to think of the next level after bruh, because this is that's what this was. It was just too much. The disrespect to the victims' families was too high, and this was really not that complicated. This could have been so simple, and I don't even know what the resolution is, because we got back because Karen Reed started her testimony started again, or testimony resumed. So we came back here to watch this. We got back to Massachusetts, but I don't know what the resolution was, and because it was this whole situation, what he did to that the victim's lawyer was so uncalled for and so necessary. There is a compromise that he is well aware of. If this gal who has nothing but a good enough diploma, aka GED, knows the compromise that he had, and he could have used, and he could still use, then the judge should know it. He doesn't have to entirely change the venue, which is actually moving where the trial takes place. Okay. There's an other option for him that he could have used it's a good compromise and everybody wins. Okay. The trial can still physically take place in Pike County. But what he can do is have jurors come in from another county or other counties if he so chooses. That would have been a good compromise. I need to let it go until tonight. Also, we're behind on this, so let me skip forward and see what happens if they come back.
All right. So Tori, you should take care of that.
Goodbye.
Thank you.
Goodbye. That's it. All right, I think. Let me just make sure. All right, I think that's it for the day. They did not. No, I don't know what the resolution was yet, Cash, because I haven't watched the end of it, so I don't know what if any resolution there was. And I'm going to say this right now: I don't think that I can tell you right now. There's not going to be a resolution that we're going to hear from the bench today, because he said he wasn't going to make a ruling from the bench. So it'll be a written order, likely. I needed Cash. I needed Pepsi and time. Although MK does brighten my mood, he does make me laugh, but you guys all do. So there you guys have it. All right, you guys, thank you so much for being here today. I appreciate each and every one of you. I will see you back tonight at 8 Central, 9 Eastern. We will discuss that hearing. All right. You guys have a great rest of your Friday. MK, enjoy your birthday weekend, bro. You deserve it. You're a hardworking man. You're a scholar and a gentleman. All right. You guys take care, and I'll talk to y'all later. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you. effort was towards it.
No militia. Finish her!
Minutes later.
We all do a little mad sometimes.